I appreciate everyone being here. We have 3 nominees on the agenda. All are ripe for consideration. Neil Gorsuch to Supreme Court, Rod Rosenstein, Deputy Attorney General, Rachel Brand to be Associate Attorney General. I want to explain how we're going to proceed. In addition to the Supreme Court nominee, we need to report out the nominees for Deputy Attorney General and Associate Attorney General. We all understand that it's important for the Department of Justice to have senior leadership in place. My intention is to have everyone speak on the judge and then vote on his nomination. Then we'll turn to Rosenstein and Brand. I'll have a statement on both of them that I'm going to put in the record so we can keep things moving. Regarding the judge, for the most part, everyone has already indicated one way or another how they intend to vote, so there isn't a whole lot of mystery about how this is going to go at our committee meeting today. But regardless, everyone should have an opportunity to explain their vote, so everybody can speak as long as they want to. But my hope is that members can try to keep their remarks within 10 minutes so that everyone can speak and we can proceed in an orderly way. Now I speak, then I'll turn to the ranking member. Today, we're considering the nomination of Judge Neil Gorsuch to serve as Associate Justice of the Supreme Court. Over the last couple months, the nominee's opponents have tried to find fault with him. That fault will not stick. And of course, we've seen that it just hasn't worked. Before the president made his announcement, the minority leader of the Senate declared that any nominee must prove himself, in his words, mainstream to get confirmed. Well, that test ran into trouble the minute the president selected the nominee. He was confirmed to the 10th Circuit 2006 by unanimous voice vote. In the 10 years since, his record on the bench has proved that the judge falls well within the mainstream. He's participated in 2,700 cases. He's voted with the majority 99% of the time, and roughly 97% of those 2,700 cases were decided unanimously. 2 of his former 10th Circuit colleagues, one was a Reagan appointee, one was a Clinton appointee, remarked upon, and now I quote them, his fair consideration of opposing views, his remarkable intelligence, his wonderful judicial temperament expressed to all the litigants, and his collegiality among colleagues, end of quote. So you get words like fair, remarkable, wonderful, collegiality from people that have served with him during that period of time, some appointed by Republican presidents, some appointed by Democrat presidents. Then you wonder what the uproar about him is all about. Legal commentators across the political spectrum have recognized that he's mainstream. Even Rachel Maddow, who isn't exactly a conservative, said the judge is a, quote, fairly mainstream choice that you might expect from any Republican president, end of quote. Once it became clear that Judge Gorsuch is mainstream, opponents then moved the goalposts and set a whole different test. Any nominee of President Trump's, the minority leader said, must prove that he is independent. Of course, there's no debate on this question either. The night that, let me turn my phone off here.
That's a good idea.
The night Judge Gorsuch was nominated, President Obama, Solicitor General Neil Katyal, I think it's pronounced, wrote a New York Times op-ed entitled, quote, "Why Liberals Should Back Neil Gorsuch," end of quote. Mr. Katyal argued that one basic question should be paramount. Quote, "Is the nominee someone who will stand up for the rule of law and say no to a president or a Congress that strays beyond the Constitution and the laws?" Question mark, end of quote. Mr. Katyal answered his own question, quote, "I have no doubt that if confirmed, Judge Gorsuch would help to restore confidence in the rule of law." End of quote. He went on to write that the judge's record, quote, "should give the American people confidence that he will not compromise principle in favor of the president who appointed him," end of quote. It's for these reasons and others that David Frederick, a board member of the liberal American Constitution Society, argued in an opinion piece that there is, quote, "no principled reason to oppose," end of quote, Judge Gorsuch, and that we, quote, "should applaud such independence of mind and spirit in Supreme Court nominees." So then another test, independence charged, didn't stick either. Next, we heard that the judge is against the little guy and for the big guy. As an initial matter, this is really a strange criticism, considering that my colleague, the minority leader, praised Justice Sotomayor as a judge who, quote, "puts the rule of law above everything else, even when doing so results in rulings that go against sympathetic litigants," end of quote. And the judge himself proves how absurd this argument is by citing a number of cases where he ruled with the so-called little guy. But regardless, it is, of course, a silly argument. No judge doing their job considers the status of the litigants before them when deciding the cases. That's why liberal Harvard Law professor Noah Feldman described the critique that Judge Gorsuch doesn't side with the little guy as a, quote, "truly terrible idea. The rule of law isn't liberal or conservative, or it shouldn't be," end of quote. In other words, a good judge listens to the arguments, regardless of who makes them, and applies the law regardless of the results. So that didn't stick. So next we heard that the judge hasn't answered questions. That argument is basically a complaint that he won't tell us how he's going to vote on a whole host of legal questions that he might have to deal with when he sits on that bench. Well, the irony here, of course, is that seeking assurances from the nominee how he'll vote on particular legal questions undermines the very independence that we demand of the Supreme Court and right now his nominees. His approach is consistent with the canons of judicial ethics and is consistent with the position taken by Justice Ginsburg during her nomination. In fact, that's where the Ginsburg rule comes from. She put it this way, quote, "A judge sworn to decide impartiality can offer no forecast, no hints for what would show, for that would show not only disregard for the specifics of a particular case, it would display disdain for the entire judicial process," end quote. Judge Gorsuch's response reflects the Ginsburg principle. And so at last, after all these charges leveled against the nominee and his record have fallen flat, we learned that the nominee should be opposed because of his record, not because of his record or his qualifications, but because of clients he had or the groups who now support him. We've heard criticism of the judge's former client, the Department of Justice, and its litigating position. Opposition on these grounds may be creative, but they're in fact baseless. Here's the inconsistency. Justice Kagan, for example, argued as Solicitor General that the government could constitutionally ban pamphlet material. When that issue was raised at her hearing, she said she was a government lawyer acting on behalf of her client. That client happened to be the same United States government that Gorsuch had worked for a while. But today, the other side is all of a sudden arguing that government lawyers should be held personally responsible for every policy or legal position that the government takes. So once again, that argument doesn't stand up under scrutiny. And finally, of course, we've heard criticism of the advocacy groups who are speaking out in support of his nomination and spending, quote unquote, dark money to issue advocacy. Now, as an initial matter, I think it speaks volumes of a nominee that at the end of the day, after reviewing 2,700 cases, more than 180,000 pages of documents from the Department of Justice and the George W. Bush Library, and thousands of pages of brief he filed as a lawyer in private practice, all his detractors are left with is an attack on the people who support the nomination. Now, as a senator who has participated in 14 Supreme Court hearings, I must say these comments strike me as really odd. To hear my friends on the other side tell it, it's only conservatives, outside groups, who are engaged in the nomination process. But we all know that isn't true. It's no secret that there are dozens of advocacy groups on the left who get involved in the nomination process. And there's absolutely nothing whatsoever wrong with that. We call it free speech. A group called the Coalition for Constitutional Values ran ads in support of Justice Sotomayor and Justice Kagan before their confirmation. The American Constitution Society touted Justice Kagan as a justice, quote, a justice for every American, end of quote. Where did their money come from? I don't know, and I suppose a lot of people think that I shouldn't say I don't care, but this is America, where people can spend their money where they want to spend it. And they can use their money for political speech or any advocacy that they want. And of course, as we see, advocacy groups on the left are engaged on this nomination as well. Liberal billionaires like Tom Steyer, George Soros, found their own dark money organizations like Next Gen Climate, a group that describes Judge Gorsuch as, quote, an extreme candidate, wrong for the Supreme Court, under any circumstances, end of quote. Everyone in this room knows that liberal and progressive groups have been pressuring the minority leader to find a reason, any reason, to filibuster the nominee. NARAL has run ads to pressure members to filibuster. We even had some groups called Progressive Change Campaign Committee target a senior and extremely well-respected Democrat over his quote-unquote squishy comments suggesting he might not filibuster. In short, they've threatened to primary any Democrat who supports the nomination. Now that's very dark. And of course, all last year, the groups on the left who coordinated an attack on me because I didn't hold a hearing on Garland. They followed me all over Iowa, ran commercials, put up billboards, even had a plane pulling a banner over a special event in Des Moines. Can you imagine that plane traveling around Iowa with that banner saying, Grassley, do your job? Or mobile billboards, do your job, at every town meeting I had. Or billboards on Fleur Avenue, Des Moines, Iowa, all over, touting 3 Republicans that were ashamed of Grassley. I found out they were Republicans maybe 20 years ago. TV ads, radio ads, paid staff bringing people to my town meetings, op-eds, clutter my town meetings with trackers, and even brought in somebody I found out from Washington State to make sure that everybody knew how bad I was. Now, that's what I know about dark money, but I don't care about it because that's the American way we do things in this representative democracy. In fact, at my town meetings, I tell people one thing up front in about 2 minutes of opening the meeting, because I don't talk, or I let them set the agenda. But I say, this is what representative government is about. I'm one half of the process, you're the other half. And how can you be representative of the people if you don't have dialogue with them? And so these people come with dialogue with me, and it's part of our democratic system. Now, I've never heard any Democrat complain about all that money that was spent last year. We had a debate, I believe then and I believe now, that we took the right course for the Senate and for the court. And as I said, regardless of who won the election, we'd process this nominee. And so we're processing the nominee. 9 o'clock on election night, everybody thought that Hillary Clinton was going to be president of the United States. But long time before that 9 o'clock, months before, I said, who's ever elected president, we're going to process that nominee. And that's what we're doing right now. That's democracy at work. By and large, I disagree with those advocacy groups on most issues, but I don't take issue with their engaging in the process and making their voices heard. And I don't try to intimidate or silence them. The bottom line is this. If you don't like the fact that issue advocacy groups are engaged in the process, the remedy is not to attack, intimidate, or try to silence them. The remedy is to support nominees who apply the law as it's written. The remedy is to support nominees who leave legislating to Congress. If you want politics out of the process, the solution is judges who apply the law as it's written and leave the policy making to the other branches. Which brings me back to where I started. Judge Gorsuch is eminently qualified. He's a mainstream judge who's earned the universal respect of his colleagues on the bench and in the bar. He applies the law as we in Congress write it, as the judicial oath says, without respect to persons, and he refuses to compromise his independence. This nominee that we're voting on today is a judge's judge. He's a picture of the kind of justice we should have on the Supreme Court. So I urge you to join me in supporting his nomination, Senator Feinstein.
Thanks very much, Mr. Chairman. In my view, this is not a routine nomination. So I want to begin with just some brief comments about what has made this different for me. The first, of course, is what happened last year, which is unprecedented. As I noted in our last meeting, throughout our nation's history, a total of 19 Supreme Court justices have been nominated and confirmed in a presidential election year. And 3 of these have been nominated and confirmed after the presidential election took place. So there was simply no reason that the nomination of Judge Garland could not proceed other than to deny the then President of the United States, President Barack Obama, the ability to fill the seat. And that's what has taken place. Secondly, press reports indicate that $7 million of dark money was spent to defeat Judge Garland's nomination. This, too, was unprecedented. However, with the nomination of Judge Gorsuch, the spending of dark money has only grown. Weeks ago, press began reporting that the Koch brothers, through Concerned Veterans for America and other conservative donors through the Judicial Crisis Network, planned to spend at least $10 million on a political campaign to support Judge Gorsuch's nomination. Since then, the National Rifle Association has launched a $1 million ad buy. And just last Friday, the Judicial Crisis Network announced another $1 million targeted to specific senators in Missouri, Montana, Indiana, and Colorado. So this nomination is not the usual nomination. It comes in a different way, and it has proceeded in a way of excessive spending of dark money that in the time I have been on this committee, I have never seen before. So this is deeply troubling, and I don't believe it's the way a serious process of evaluating a Supreme Court nominee should be conducted. I want to be clear, though, although my vote will not be based on these factors, I strongly believe that the expenditure of millions of dollars, of unknown dollars, should not be permitted in the nomination of a Supreme Court justice. However, we have had 4 days of full and fair hearings, and today we begin our markup. I want to thank the chairman for his leadership and the very cooperative manner in which the hearings were conducted. So I want you to know, Mr. Chairman, you're allowing all members to fully ask questions and have the time they needed to examine Judge Gorsuch's record and hear from outside witnesses is very much appreciated. So thank you. In reviewing the list of Judge Gorsuch's decisions on the 10th Circuit, 2 stand out as appearing to indicate his view of how a law should be interpreted and whether precedent should be overturned. And the first, which has been talked about before, but nonetheless very important, is a case called Trans Am Trucking. The driver, Alphonse Madden, was stranded in sub-zero temperatures for several hours with frozen brakes on the trailer and no heat in his cab. It was so cold, his torso was numb and he could not feel his feet. After waiting hours for assistance, Mr. Madden was instructed to drive the cab and the trailer together or not at all. When he could no longer stand the cold, he unhitched the trailer and drove to get help. Because of this, he was fired. The Department of Labor found he was illegally fired for refusing to operate the vehicle. In fact, the administrative law judge, the Administrative Review Board, and the majority of the 10th Circuit all agreed that he had been illegally fired for refusing to operate the vehicle as instructed by his employer. Judge Gorsuch disagreed. Instead, he argued in his dissent that the term operate should be interpreted by the Oxford Dictionary's definition, that operate should include only operating the cab of the truck, and Madden's employer could fire him with impunity. I find this striking. First, Judge Gorsuch's argument ignores the reality that Mr. Madden was given an impossible choice: risk your own life or the life of others on the road. Secondly, it ignores the fact that judges are not evaluating cases and interpreting law in a vacuum or a law school classroom, but rather cases are about real people and real life. In fact, the majority of his own court on the 10th noted that Judge Gorsuch's narrow interpretation of the word operate was based on one dictionary, while they had found a different dictionary definition that supported their reading of the statute. Simply put, which dictionary a judge happens to select should not and cannot determine whether a just outcome is achieved in a case. The second case that really stood out, and the father testified before us, was Luke P. Luke Perkins was diagnosed with autism at 22 months. As he got older, the amount of structure and educational services he needed increased. In response, Luke's parents and grandparents did all they could. They dug deep into their savings. They sought support from the school district, as provided for under the Individuals with Disabilities Education Act, known as IDEA, but they were denied. The independent hearing officer, the administrative judge, and the United States District Court all determined the school district was wrong to deny funding. But when the case got to the 10th Circuit, Judge Gorsuch inserted the word merely into the standard. Now, up to this point, the 10th Circuit had held that the educational benefit had to be, quote, more than de minimis, end quote. Adding the word merely made a narrow interpretation of the law even narrower. As Luke's father testified to us, and I quote, Judge Gorsuch felt that an education for my son that was even one small step above insignificant was acceptable, end quote. Luckily, the Supreme Court unanimously rejected Judge Gorsuch's interpretation of the law, actually, during our hearings. In both cases, Judge Gorsuch unnecessarily went out of his way to imply his own view of what the law should be, even when it would have devastating effects on people's lives. Because these cases were troubling, I had hoped Judge Gorsuch would better explain his judicial philosophies and personal views at this hearing. But that did not happen. Judge Gorsuch's views were difficult to discern because he refused to answer many questions, even basic questions that have been answered by previous nominees. For example, Senator Blumenthal asked the judge if he agreed with the results of Brown v. the Board of Education, one of the most important cases in our history. I think everyone would agree. Rather than agreeing that schools shouldn't be segregated, Judge Gorsuch instead said it was, quote, the correct application of precedent, end quote. To be clear, when he asked if he supported Brown, Judge Gorsuch refused to directly answer. In contrast, when Justice Kennedy was asked about Brown, he replied, and I quote, I think Brown v. Board of Education was right when it was decided, and I think it would have been right if it had been decided 80 years before, end quote. In another exchange, Senator Franken asked about a wave of recent laws to restrict access to voting. These laws were found to target African Americans with surgical precision. Senator Franken discussed the effect of these laws, but he simply asked if Judge Gorsuch was disturbed by efforts to disenfranchise African American voters. The question has but one easy answer, and it's yes. Yet, instead of agreeing, Judge Gorsuch ducked the question. He responded, and I quote, if there are allegations of racism in legislation in the voting area, there are a variety of remedies, end quote. Even Justice Alito was more candid. When asked about affirmative action, Justice Alito replied, I have personal experience about how valuable having people with diverse backgrounds and viewpoints can be. Having a diverse student body is a compelling interest. Going even further, in 1987, Senator Biden asked Justice Kennedy not what he thought about affirmative action generally, but whether the voluntary affirmative action plans are legally permissible. Judge Kennedy unequivocally responded yes. Unfortunately, Judge Gorsuch's answers were so diluted with ambiguity, one could not see where he stood even on big and long-settled cases. When I asked Judge Gorsuch about his work at the Department of Justice involving the Bush administration's defense of the use of torture, despite providing relevant documents, Judge Gorsuch said only that, quote, his memory is what it is, and it isn't great on this, end quote, and that the position he took on torture, quote, was the position that clients were telling him, end quote, to take. Not only did he not answer my question, he raised an additional concern. I strongly believe that when you work for the government, either as a lawyer or a policymaker, it's important to comment on the legality of the issue you advise or write. To say, I did what they wanted, is not enough, particularly if the legality is contradicted by both law and treaty. I also believe it's important to remember the context. At this point, our country was involved in detaining people indefinitely, without charge or trial, leaving them with no rights, no meaningful opportunity to challenge their confinement. The government had also decided the executive could order the use of certain enhanced interrogation techniques that included waterboarding, stress positions, and sleep deprivation, as well as a host of other techniques which would and did result in death and serious debilitation of detainees. It was April 2004 when the public first learned about the prisoner abuse chronicled in the Abu Ghraib photos. Then in June of 2004, information was leaked to the media that the Department of Justice had issued legal opinions that stated enhanced interrogation techniques were within the law unless they inflicted the kind of pain associated with organ failure or death. Judge Gorsuch reached out to the White House political director in November 2004, approximately 6 months after these revelations, to say how he wanted to help the cause and be a full-time member of the team. Then, in March 2005, he reached out to the chairman of the Republican National Committee, who vouched for Gorsuch as a true loyalist and a good, strong conservative. Judge Gorsuch ultimately joined the Bush administration in June of 2005. Through our examination of his documents, we learned that during his tenure at the Department of Justice, he was involved in efforts to strip detainees of their ability to have habeas cases heard by federal courts, defend and protect the Bush administration's position on torture, and issue an expansive signing statement on the Detainee Treatment Act. These statements were used to highlight parts of the law the administration intended not to follow. Importantly, we learned that Judge Gorsuch advocated for the Bush administration to issue a broad signing statement. He said it could be used to, and I quote, help inoculate against the potential of having the administration criticized sometime in the future for not making sufficient changes in interrogation policy in light of the McCain portion of the amendment. This statement clearly, and in a formal way that would be hard to dispute later, puts down a marker to the effect that the view that McCain is best read as essentially codifying existing interrogation techniques. Nothing could be farther from the truth. Judge Gorsuch's email shows a knowledge of the Bush administration's position on torture. It also demonstrated he supported efforts to codify existing interrogation policies, such as waterboarding and other extreme techniques. In our written questions, I asked again about his views on enhanced interrogation techniques. I know something about them. The Intelligence Committee, while I was chairman, has in classified stata over 7,000 pages with 32,000 footnotes that document all of this. I tried to understand his opinions on right and wrong and whether he was at all disturbed by what our government was doing. Unfortunately, once again, the answers I got were non-responsive. For example, I asked Judge Gorsuch what he meant when he suggested that a signing statement could inoculate the administration if they were later criticized for not making, quote, sufficient changes to the interrogation policy, end quote, based on the McCain Amendment. Judge Gorsuch responded once again that he was, quote, a lawyer advising a client, end quote, and that his client, the government, was arguing that the McCain Amendment simply codified existing policies. Judge Gorsuch's defense is that he was only doing what his client wanted him to do. Many of his colleagues, of my colleagues, on the other side of the aisle have praised Judge Gorsuch's qualifications. And there's no question he's well-educated and well-credentialed. But we're not just evaluating a resume. If we were, every Supreme Court nominee would pass unanimously, 100-0. Rather, all of us evaluate not only their education and experience, but also their judicial philosophy, temperament, and views on important legal issues. We do this because if confirmed, a nominee's decisions will affect the lives of all Americans for generations. And as I've said, our job is to assess whether the nominee will protect the legal and constitutional rights of all Americans, and whether the nominee recognizes the humanity and justice required when evaluating the cases before him. Unfortunately, based on Judge Gorsuch's record at the Department of Justice, his tenure on the bench, his appearance before the Senate, and his written questions for the record, I cannot support this nomination. Thank you very much, Mr.
Thank you. Senator from Utah.
Well, thank you, Mr. Chairman. Before making a few comments about the nomination of Judge Neil Gorsuch, I want to remind my colleagues about the committee's traditional practice regarding Supreme Court nominees. That practice was memorialized in a letter signed in June 2001 by incoming Chairman Patrick Leahy and by myself as the then-ranking member on this committee. Mr. Chairman, I ask consent that that letter be placed in the record at this point.
Without objection, so ordered.
Now, the letter states, quote, the Judiciary Committee's traditional practice has been to report Supreme Court nominees to the Senate once the committee has completed its considerations, unquote. Now, this letter was cited several times last year by those demanding a hearing on the previous nominee, but it says nothing whatsoever about how the committee should consider a particular nominee. The best way to evaluate an individual nominee depends on many factors. And last year, we obviously faced some unique circumstances. Though this letter was irrelevant last year, it is certainly relevant now because we have completed our consideration of the Gorsuch nomination. Since only 5 current committee members were here in 2001, I wanted to make sure everyone was aware of our past practice. Now, the conflict over the Gorsuch nomination is not about whether our fellow citizens try to influence the president's nominations or the Senate's advice and consent. Of course they do, from both the left and the right. Anyone who thinks that specific left-wing groups have not moved mountains and spent like mad to influence past Supreme Court nominations has been living in a parallel universe for the last 30 years. Nor is the conflict over the Gorsuch nomination about whether President Obama had a right last year to appoint this nominee. No, the President does. That's what checks and balances are for. The Constitution gives the President the power to nominate judges and gives the Senate the power of advice and consent on those nominations. Both the President and the Senate legitimately exercised their respective powers last year. The conflict over the Gorsuch nomination is instead about two radically different ideas about the role of judges in our system of government. America's founders designed the judiciary to impartially interpret and apply the law. The judges did not make and cannot change to decide individual cases. The law, not the judge, determines the results, and the way to change the results is to change the law. The other idea is that deciding cases is a means to the end of judges addressing issues and advancing political interests. In this view, judges not only may, but sometimes should change the law so that their decisions produce politically desirable results. The judge, not the law, determines those results, and the way to change the results is to change the judge. Judge Gorsuch's supporters and opponents agree on one very important thing. We both believe that he will take the law as he finds it and apply it impartially, refusing to bend his decisions in light of who the parties are or which political interests might be affected. I believe that's why he should be confirmed. His opponents believe that's why he should be filibustered. And like America's founders, I believe that such impartiality and independence help keep the judiciary within its proper role in our system of government. That role by design is necessary for the liberty that we now enjoy. Judge Gorsuch's opponents see impartiality and independence as obstacles to overcome on the path to a fully politicized judiciary. That is why they demand that he prejudge cases, pre-comment on issues, and take sides before cases even come before him. The Democratic leader repeated over the weekend that if a nominee can't get 60 votes, the solution is to change the nominee. At least that is his current position, the one he takes each time the White House and Senate are under Republican control. Put a different way, he wants the Senate to do as he says now, not as he did then. That is not a principle, it's just partisan politics, and it is a very poor guide for the confirmation process. The choice we face is between impartial or political judges, between judges who follow the law and those who attempt to control the law. Judge Gorsuch is, by any measure, a superbly qualified nominee who is enthusiastically supported by those who know him best, regardless of their partisan or ideological views. He will be impartial, fair, and open-minded. He will be exactly the kind of justice that America needs and that our liberty requires. And he has had support from some very liberal lawyers who know how good he really is. And I hope that this committee will support him, and I hope the Senate will support him, and he will become a justice on the United States Supreme Court.
Senator Leahy. Thank you, Mr. Chairman. And first off, I agree with Senator Feinstein. You've made sure to follow the practice we've always had, allowing everybody to be heard, and I do appreciate that.
That's the Leahy rule.
Well, we've made the rule of this body, and I think that's a good thing. We have on the agenda a couple other items, and let me just mention briefly the nomination of Rod Rosenstein to be Deputy Attorney General. Mr. Rosenstein has spent 27 years in the Justice Department, the last 12 years as U.S. Attorney for the District of Maryland. He actually has a reputation for integrity that's unusual for this administration's nominees. But if he's confirmed, he's going to inherit a situation that no Justice Department nominee has faced since 1973, an active criminal investigation into a sitting president's campaign and administration. Every week, as we know, new evidence surfaces indicating that Trump campaign officials colluded with a hostile foreign power to influence the election and undermine our democracy. Numerous senior officials from the Trump campaign have been caught lying about their communications with Russian officials. Even the Attorney General, who would be Rod Rosenstein's boss, was forced to recuse himself after the press revealed that he misled this committee, this Judiciary Committee, about his own contacts. And time and again, the White House has shown they're not going to respect the independence of any investigation. So whomever assumes the role of Deputy Attorney General in this administration will face extraordinary tests of integrity. And it's against this unprecedented backdrop that we will consider Mr. Rosenstein's nomination today. In fact, anyone paying attention, let alone somebody familiar with the Justice Department, understands this situation calls for appointment of a special counsel. Americans deserve an investigation that is not only independent, but one that might inspire public confidence. The issue is too important for us to skew for partisan motivations. Country has to come before party. Now, Mr. Rosenstein assured me and others that on the matter of Russian interference in our election, he is on the American side, not on the Russian side. And I trust that he'll hold true to that statement. But if confirmed, he will also face other critical tests as well, including whether you continue to support the Justice Department's Smart on Crime initiative, focusing the most serious criminal penalties on the most serious offenders. And so I just wanted you to know, Mr. Chairman, I will vote to advance Mr. Rosenstein's nomination today because I expect him to do the right thing when facing such pivotal issues. Now, the other matter we have on the agenda, of course, is Judge Gorsuch. I said weeks ago that I was approaching this nomination with an open mind. My vote on Supreme Court nominations have never been about reflexive partisanship. I have evaluated every nominee in the merits. And I have voted to confirm 6 Supreme Court nominees of Republican presidents. Unlike committee Republicans' unprecedented treatment of Chief Judge Merrick Garland, I take my constitutional duty to independently evaluate a president's Supreme Court nominee seriously. And of course, that includes Judge Gorsuch. For those of us who hope that Judge Gorsuch would use his confirmation hearings to give insight into the type of justice he would be, we were certainly disappointed. Based on his record, I had concerns about his views. I had concerns whether he'd bring a partisan agenda to the court. Judge Gorsuch did nothing to allay those fears. In fact, I could say he solidified them. I cannot recall a nominee, and I have voted on every member currently in the Supreme Court, plus many before. I cannot recall a nominee refusing to answer such basic questions about the principles underlying our Constitution and about how he interprets those principles. These are fundamental questions that we should ask every nominee seeking a lifetime appointment to our highest court. Some of the questions I asked them were not intended to be difficult. Several could have been answered by any first-year law student with ease. Yet unless we were asked about fishing or basketball, Judge Gorsuch stonewalled and avoided any substantive response. He was actually excruciatingly evasive. His sworn testimony, his approach to complying with this committee's historic role in the confirmation process have been patronizing. That's a disservice to the American people. And it's a blight on the confirmation process. Judge Gorsuch claimed he did not want to prejudge potential cases. Well, that's a valid concern. We all accept that. But only within reason. It should not be used to evade questions on long-settled precedent or on the meaning and purpose of constitutional provisions. He wouldn't even state whether he agreed with certain landmark Supreme Court cases, such as Brown versus Board of Education. Is there anybody on this committee or elsewhere who would disagree with Brown versus Board of Education? He refused to say whether he believes the Equal Protection Clause applies to women. He refused to say whether the framers of the First Amendment believed it permitted the use of a religious litmus test. He refused to provide information regarding his selection by extreme special interest groups and a billionaire businessman. And he even refused to confirm whether he would continue to recuse himself from matters involving that billionaire, as he has done on the 10th Circuit, even if presented in the Supreme Court with the exact same facts. Now, I actually hoped that Judge Gorsuch would be more transparent and forthcoming in written questions after giving time to carefully consider these questions away from the lights and the camera. But he again declined. He refused to expressly acknowledge that Congress has war powers, even though every high school student knows the Constitution gives Congress the power to declare war. He again misstated the holding of Citizens United in an attempt to evade my question about Congress's ability to enact campaign finance laws. Judge Gorsuch provided no answer at all to questions regarding the Supreme Court's decision in Shelby County, which gutted the Voting Rights Act. Refused to answer a question about women's rights to obtain contraception. He again refused to answer whether the First Amendment prohibits the president from imposing a religious litmus test, even when the Trump administration has adamantly claimed such a litmus test is not at issue with his travel ban. My family, I was brought up to believe in the First Amendment. It allows you to practice any religion you want or none if you want. And that we live in a country that does not impose religious tests. And so I think that Judge Gorsuch's non-responsive testimony makes it difficult for this committee to fulfill its constitutional duty to examine his judicial philosophy and evaluate his nomination. Now, perhaps we should not be surprised that the nominee would not respect the role of this committee after Senate Republicans let rank partisanship blind them from their constitutional duty to consider Chief Judge Merrick Garland. My distinguished colleague from Utah, Mr. Hatch, has read a letter into the record. Well, he believed in that, I guess, back then, but not now, because Judge Gorsuch was not even afforded, or Chief Judge Merrick Garland wasn't even afforded the courtesy of a hearing. Some members even refused to meet with him. What a shameful stain on the proud history of this committee. The lesson Judge Gorsuch may have learned from Senate Republicans' treatment of Merrick Garland is that this committee is nothing more than a partisan rubber stamp. Judge Gorsuch appears to believe that since Republicans are in the majority, he need not answer questions, and he's somehow entitled to confirmation. Fortunately, the majority leader appears to believe that too, and his most recent statements amplifies that. You know, previous nominees, both Republicans and Democrats, respected this committee's constitutional role by answering questions in a substantive way, not with platitudes or aphorisms. One law professor wrote in The Atlantic that Judge Gorsuch was by turns condescending, evasive, and even dishonest. In fact, there's not much to say that he, in his aw shucks gentlemanly way, gaslighted the committee in a genteel but nonetheless Trumpian style. That description befits a nominee who the White House Chief of Staff stated has the vision of Donald Trump. Judge Gorsuch did not do nearly enough to prove Mr. Priebus wrong. In fact, he said that marriage equality is settled law, but refused to say the same thing about a woman's right to choose. That is telling, considering it's the same position taken by President Trump, who promised time and again to nominate justices who'd overturn Roe versus Wade. In fact, when he's pressed on this issue, Judge Gorsuch claimed his personal views did not matter. He refused to discuss them. In the article by Garrett Ebbs in The Atlantic put it, Judge Gorsuch implied the role of a judge is, quote, a job which calls apparently for neither values nor any firm connection to human life as it is lived. Chairman, I asked the article titled The Fundamental Dishonesty of the Gorsuch Hearings be included in the record.
Without objection, so ordered.
Because actually the American people know better. Certainly the people I hear from in Vermont do. We know the court decisions, especially Supreme Court decisions, are not simply detached applications of neutral principles. If they were, well, then all judges would reach the same results for the same reasons. But they do not. Legal decisions are not mechanical. They are matters of interpretation, but they're also often matters of justice. One Supreme Court justice said more than a century ago, when we take our seats on the bench, we are not struck with blindness and forbidden to know as judges what we see. Now, whether you acknowledge it or not, Judge Gorsuch's record says a lot about his judgment and his sense of justice. In a policy wrote the Justice Department, as Senator Feinstein has noted, he embraced broad and discredited assertions of executive power. As a judge, he twisted statutory language to limit the rights of workers and women and children with disabilities. And he reached for broad constitutional questions that were not before him in order to advance his agenda. Judge Gorsuch complained about liberals relying on the courts to vindicate their constitutional rights. But he had no problem rubber stamping the far-right social agenda when he ruled that employers could control their employees' access to contraception. When the far-right groups that vetted him looked at that record, they liked what they see. The leader of that vetting has said that the process was driven not by, quote, who's a really smart lawyer who's been really accomplished, close quote, but by a search for someone, quote, who understands these things like we do, close quote. And we know that these groups, and the millionaires who fund them, have a clear agenda, one that's anti-choice, anti-environment, pro-corporate. These groups are confident that Judge Gorsuch shares their agenda. Well, that should concern all of us. I've thought a lot about this nominee. I've thought about whether I could find a way to support him. When I reached the decision to support Chief Justice Roberts' nomination, I did so knowing that he was conservative and knowing that my own party leader was going to oppose it. But I also believe that his record as a judge at the time showed a commitment to restraint and minimalism. Many other Democratic senators voted the other way, and I respect that. But Chief Justice Roberts' record allowed me to take him at his word that he did not have an ideological agenda. I said then that a vote to confirm requires faith that the words he spoke to us had meaning, close quote. But compared to Chief Justice Roberts, there's a yawning crevasse between the words of Judge Gorsuch spoke to us and his actual record. When viewed in isolation, perhaps his words would appear satisfactory. But when viewed in the context of his troubling tenure at the Justice Department, his unprecedented selection process by far-right interest groups, and his judicial record evidencing a partisan agenda, then they're unconvincing. These are extraordinary times. This is an extraordinary nomination. Last year, this committee forever tarnished its reputation. In 100 years of bipartisan tradition, to do the majority leader in Donald Trump's partisan bidding. Senate Republicans held a Supreme Court vacancy and an eminently qualified nominee hostage with the sole and express intent to deny President Obama an appointment to the Supreme Court, an appointment that he had every right by precedent, by law, to make. Now, since taking office, President Trump has focused his attention on targeting the very communities that are most at risk by his choice for the Supreme Court, a nominee who the White House tells us shares his agenda. This nominee has since refused to address any substantive issues during his testimony. He's left this committee and the American people with only unresolved concerns. The majority leader is now promising to rush this nominee toward confirmation, even to depriving senators of a full debate on the Senate floor. The majority leader has promised to use whatever tactic is necessary to get his way, to make sure that Donald Trump's nominee is confirmed, even if that means forever damaging the United States Senate. Now, I respect this institution as much as anyone. I never expected to be here long enough to become the dean of the Senate, but I have. And for those 42 years, I've devoted myself to the good the Senate can accomplish. But I cannot vote solely to protect an institution when the rights of hardworking Americans are at risk. Because I fear that the Senate I would be defending no longer exists. I've often said that the Senate, at its best, can be and should be the conscience of the nation. But I must first and foremost vote my conscience, vote today and later this week. My conscience will not allow me to ratify the majority leader's actions. Not last year, not this year. I will not, I cannot support advancing this nomination. Thank you, Mr. Chairman.
Thank you. Senator Graham.
Thank you very, very much, Mr. Chairman, and I appreciate the way you've run the committee, and we've had a spirited days of talking about Judge Gorsuch. I will vote for him with a very clear conscience for whatever that matters. One thing we need to look at is the ABA. I don't know how they missed everything y'all saw. They interviewed 5,000 people, 500 people that worked with him closely, a 900-page report that puts him at the top of the legal profession. And I think they missed the part about where he yearns for the days of Plessy versus Ferguson. Actually, I missed that too. I don't know what hearing y'all were attending. To say that this man somehow wishes Brown versus Board of Education wasn't decided, somehow wishes for the days of pre-Griswold, is a bit of a stretch. Here's what he said. Cases and controversies are his life's work. Okay. You know, you just don't drop by the Supreme Court and say, you know, I'd like to get rid of Brown versus Board of Education. Where do I go? There's a system for a case to get to the Supreme Court. That system is pretty well established. And when it came to Griswold, he pretty well explained the system. It means that somebody somewhere would have to pass a law outlawing contraception between married couples. Some politician would have to do that somewhere. Somebody would sue, and the Supreme Court would have to take the case to change Griswold. And he said, I can't imagine that crazy scenario that we would take the case and somebody would pass a law going back to the days before Griswold. But here's the deal. If all that happened, shouldn't he listen to what the side had to say? If the Supreme Court decided to take that case, which they wouldn't, if some politician somewhere could convince other politicians to go back to that period, the point is to suggest that Judge Gorsuch somehow has in his heart a disdain for Brown or Griswold because he won't give you the answer that you think he should give is a bit of a stretch and, quite frankly, unfair to the judge. So we've had one successful filibuster of a Supreme Court nominee, and that was bipartisan with Abe Fortas. By the end of the week, that will still be the case. We will not have a successful filibuster of a Supreme Court nominee because if we have to, we will change the rules, and it looks like we're going to have to. I hate that. I really, really do. Senator Schumer, who's a good friend, we work on a lot of things, keeps talking about reasonable and mainstream as if he knows what reasonable and mainstream is on our side of the aisle. Do you have any idea how offensive I find that comment in light of what I did with voting for Sotomayor and Kagan? I thought they were reasonable. I thought they were mainstream. I thought they were progressive in the role of President, in the mold of President Obama, as according to Greg Craig. He assured the Democratic base that when he picked Elena Kagan, she's a progressive in the mold of Obama himself. I expected that. I expected Sotomayor and Kagan to be people that President Obama would choose, not somebody I would choose. And the only thing I ask of these two fine ladies, are you really qualified for the job? Do you have the character, the temperament, the judgment? Can you meet the Federalist Paper 78 test? I thought they did with flying colors. And people on our side, some outside groups, some people inside the Senate, tried to suggest that Elena Kagan was unfit for the job because when she was working at Harvard, she supported moving the ROTC unit off campus. Well, I didn't like the fact they kicked the ROTC unit off campus in Harvard, but if you look at the way Elena Kagan had lived her life and the way she had performed her duties as judge and solicitor and everything else, it was hard for me to believe she was unpatriotic, therefore not qualified to sit on the highest court of the land. It just made me believe she was in Harvard and thinks like people at Harvard about ROTC. Nothing more, nothing less. Sonia Sotomayor, I remember she gave a speech one time about judges, talking about the more diverse the court, the better, and said that, you know, white men will have a hard time understanding some of the situations that exist in modern society because they're white men. So that created a big dust-up on our side that somehow all of a sudden she hates white men, she's a racist. Well, the reason I didn't buy that is because of the way she lived her life. She'd interacted with a lot of people over a long period of time, and all of them had the same view of her, that she's a well-qualified, extremely capable, articulate, good person who had been a mainstream judge. So I didn't buy for 1 second because she made a speech somewhere about diversity that all of a sudden she was unfit to serve because that may suggest she can't be fair to white men. If you had looked at her life at all and listened to what people had to say about her, you would realize pretty quickly that she was qualified and wasn't a racist. So when I hear Senator Schumer say, change the nominee, don't change the rules, that's an absolute slam on a fine man. We're not going to change the nominee. When it comes to President Trump's judicial philosophy, if you know what it is, you're doing better than I am. I have no idea what his judicial philosophy is. He's been to court a lot, I can tell you that. He appreciates the courts, probably more than any president in history. But here's what I do appreciate about President Trump. He listened to people who understand what a conservative jurist is all about. He listened to a lot of people. And he came up with a list that I applauded him on. I could vote for any 21 people he put out before the election. And they say, well, he's under investigation. He shouldn't be allowed to pick. Bit of a stretch, but let's say it's Mike Pence. Who's he going to pick? Say something happens to him. Let's say it's Paul Ryan. Who's he going to pick? Let's say I got 99% more support than I actually got running for president. Who would I have picked? I would have picked him. Because you can't do any better over here. I think Sotomayor and Kagan were great picks for y'all. I think Neil Gorsuch's a great pick by a conservative president and will be a great member of the court. And he's going to get there. There's nothing wrong with him. There's a lot wrong with modern politics and the Senate. And we can all look in a mirror and find some blame somewhere. The bottom line here is that when it comes to qualifications, the ABA said it best. The rating of well qualified is reserved for those found to merit the committee's strongest affirmative endorsement. So when it comes to Brown versus Board of Education and Griswold, that's just a bunch of political theater. I think the ABA saw the judge for who he really is. Mainstream, competent, highly qualified. To all the people who served with Judge Gorsuch in a variety of roles throughout their lives and his, they told us without any hesitation he's one of the finest people they know. So when Nancy Pelosi says, if you breathe air, drink water, eat food, take medicine, or any other way interact with the courts, this is a very bad decision. I think that says more about Nancy Pelosi than it does Judge Gorsuch. So, from a qualification point of view, there is no argument. From a character point of view, there is no argument. From the outcome of the election, I am glad that President Trump chose Neil Gorsuch. He could not have done better. And I did not expect him to win. This is what I said in March 2016. I've been telling everybody on my side she's going to pick somebody probably more liberal than President Obama's going to send over in a few days. Of course, Garland. I'm going to vote for that person and think they're qualified. The president deserves the right to pick judges, their philosophy, and that goes with winning the White House. That just gets us back to Garland. Joe Biden told us what he would do if a vacancy occurred in the last year of Bush's 41st term. There was talk about a Republican going to retire. And here's what Joe said. If someone steps down, I would highly recommend the president not name someone, not send up a name. If Bush did send someone up, I'd ask the Senate to seriously consider not having a hearing on that nominee. That was said at the time when the primary process, the election was ongoing in 1992, the last year. When you look at the history of the Senate, I think there's one time where you need a president of one party and Senate of another that somebody was confirmed in an election year. The bottom line is, I don't think Judge Garland was treated different or unfairly than what y'all would have done. And let me just say this to your faces. If the roles were reversed, I don't believe 1 minute that you would have given the accommodation you're asking us to have given Garland, given the behavior of what you've done in the past. So this idea somehow that if this had happened in Bush's last year, 43, y'all would have allowed him, after the primary season was afoot, to pick somebody and put him on the court and defy history is just laughable to me, given what you've done. Senator Schumer and a few others led a wholesale filibuster of everything Bush, 43, in his first term. I was in the Gang of 14. We lost 2 circuit court judges as a result of the deal, but the extraordinary circumstances test held until 2013. And in 2013, with the concurrence of President Obama, because I called him and asked him, please don't do this, he says, no, I got to. Y'all are being unfair to me. I don't think the facts bore that out. Just you changed the rules for everything below the Supreme Court. You had a chance to grab power, and you grabbed it. So when you complain about Garland, it's the arsonist complaining about the fire, as far as I'm concerned. Doesn't bother me one bit in terms of the way Judge Garland was treated, even though he was a fine man, given the way the Senate, given the Joe Biden view, given reality. What does bother me is where we're headed. And here's where we're headed. We're headed to a world where you don't need one person from the other side to pick a judge. And what does that mean? That means the judges are going to be more ideological, not less. It means that every Senate seat is going to be a referendum on the Supreme Court. And that if you ever wondered about how important the Senate is, you're going to find out it becomes increasingly more important now. Because if you don't have a majority, you can't nominate and pick the judges, because you can't count on anybody from the other side helping you, because they're not required to do so and they don't have to do so. So I think the damage done to the Senate is going to be real. So as to this fine man, I regret that he had to go through some of the things he's had to go through. The hearing actually was pretty well conducted, I thought. A lot of you asked really, really good questions. And some of you asked questions you know he couldn't answer. And some of his answers, I think, were taken out of context. If anybody really believes that this man wishes for the days of a country without Brown, then I think you're not being fair to the judge. What he's telling you is I decide cases and controversies. And as to Roe v. Wade, it is the law of the land, but I can assure you the rights of the unborn have not been settled, that we're going to fight on our side, that we're going to push the concept that at 20 weeks, our country is not going to allow wholesale abortion on demand, where we're one of 7 nations in the world that allows an abortion at the 5th month of pregnancy. In that case, if it ever becomes law in the Senate, or this president will sign that law, if we never get it through the Senate, some judge somewhere will have to listen to that case in light of Roe. And all I ask them to do is listen. So there's going to be cases and controversies around the unborn for a very long time to come. Here's what I can tell you about Judge Gorsuch. He will listen. He applied the president in the very emotional case involving the autistic young man. He applied the law that existed in his circuit. That's exactly what he should have done. So as to detainees, it's not just somebody in the abstract I'm talking about. I know the man. I know exactly the role he played. I know that the Senate voted for my amendment 84-14, which said that the Combat Status Review Tribunal hearing would be appealed to the D.C. Circuit Court. As an adequate substitute for habeas, the court disagreed 5-4. I know that he said in front of the world that the Detainee Treatment Act outlaws waterboarding and that no man or woman is above the law. I know exactly what Senator McCain said about his own amendment because I helped him draft it. And rather reading a relatively long quote, he says, this amendment just codifies the current practices of the Bush administration. I know a lot about signing statements. I know a lot about Neil Gorsuch. I can tell you as a lawyer, he was honest, he was trustworthy, he was smart, and he faithfully represented his client. No more, no less. So I will vote for him. My conscience is clear about a lot of things. I remember all the nice things said about me when I decided to be the only one on our side to find Sotomayor and Kagan qualified to sit on the court. I remember Harry Reid saying, I wish more people were like Senator Graham. Maybe in the future there will be. I say that knowing my faults. I'm a Republican. I'm partisan at times, like all of us. I've tried to play it fair when it came to the court. I tried to honor elections regardless of whether or not the person I voted for won. And I haven't voted for anybody who's won in 12 years. So don't follow my political advice as to who to vote for. But I do believe I'm following the Constitution when I voted for Sotomayor and Kagan and the traditions that have been in existence for 200 years. Anthony Scalia got 98 votes. Kennedy got 97. Souter got 90. Clarence Thomas, 52-48. I think we all know what that was about. Ginsburg, 96. Breyer, 97. Roberts, 78. Alito, 58. Senator Sotomayor, 68. Elena Kagan, 63. This will be the last person that will be subject to a filibuster, which was in effect in 1948. Because the Senate traditions are going to change over this man based on the times in which we live. And I find it ironic and sad that we're going to change the rules over somebody who's lived such a good life, who has been such a good law judge for such a long time. It says more about the Senate than it does Judge Gorsuch.
Senator Durbin.
Thank you, Mr. Chairman, and thank you for your fair administration of this hearing. I'm honored to represent the city of Chicago, and we've got some basic stories that are taught to all newcomers on the political scene. And one of them involves a former former judge whom many of us knew personally, Abner Mikva. Abner Mikva was a law student at the University of Chicago, and he decided that in 1948 he wanted to volunteer to work on local campaigns for Paul Douglas for the United States Senate and Adlai Stevenson for governor. So he went to the 5th Ward headquarters. Ward headquarters are a big deal. They were in the city of Chicago. And the ward committeeman, Timothy O'Sullivan, was there. And this new law student, Mikva, walked in and said, "I'd like to volunteer to be part of the Douglas and Stevenson campaign." Timothy O'Sullivan took the stump of a cigar out of his mouth and said, "Who sent you?" Mikva said, "Nobody sent me." Sullivan said, "We don't want nobody sent." Mikva told that story because it really kind of gets to the heart of politics in that city and a lot of other places, and it's a fair question, isn't it? Isn't it a fair question about Neil Gorsuch? Who sent him? Why are we considering this man for a lifelong appointment to the highest court in the land? And the answer is obvious. We know who sent him. I have to agree with Senator Graham. I don't know what Donald Trump's I know his political philosophy a little bit. I don't know his judicial philosophy as president. But we sure do know the judicial philosophy of the Federalist Society, which was given the responsibility of coming up with the list of nominees to fill the Scalia vacancy on the Supreme Court. They did it. Candidate Donald Trump announced that list, which has been referred to, of 21 names. In fact, the Federalist Society takes pride in the fact that they say that under Republican presidents, every appointment to the Supreme Court has either been a member of the Federalist Society or cleared by the Federalist Society. Think about that for a second. I don't remember seeing the Federalist Society in the Constitution, but they've come to play a constitutional role when there's a Republican president. They pick the Supreme Court nominees. If you ask them, well, what do you use as a criteria? I'll go back to another Chicago story from a fellow I worked for. His name was Cecil Partee. He used to say in politics, for every issue, there's a good reason and a real reason. What's the good reason the Federalist Society tells us for their selection of nominees? Well, it goes back to a speech in 1985 by Edwin Meese to the Federalist Society, where he tried to come up with some basic definitions of what they were all about. He said they were rooted in the text of the Constitution as illuminated by those who drafted, proposed, and ratified it. He called this Federalist Society standard a jurisprudence of original intention, contrasted it with the misuse of history by jurists who saw in the Constitution's spirit things like, quote, concepts of human dignity, close quote, with which they turned the Constitution into a, quote, charter for judicial activism. Have we heard these phrases, originalism, judicial activism, over and over and over, and we are told, rest easy. Neil Gorsuch is an originalist. But if you're going to get into a real analysis of what constitutional originalism is all about, be sure to read the words of Justice William Brennan, who said that anyone who had ever studied in the archives knew better than to believe that the records of the Constitutional Convention and the ratifying conventions offered so certain, exact, and singular a verdict as that which Meese expected to find there. Brennan called the idea that modern judges could discern the framers' original intention, quote, little more than arrogance cloaked as humility, close quote. So excuse me if I'm skeptical about the good reason why the Federalist Society gets to pick Supreme Court nominees for Republican presidents. Perhaps, let me suggest, a real reason. Who belongs to the Federalist Society? Who funds the Federalist Society? To a point made over and over by Senator Whitehouse, they allow their donors to remain anonymous, but some do publicly disclose that they contribute. Who would they be? Try the Koch brothers, try the Richard Mellon Scaife Family Foundation, try the Mercer family, which I'm reading more and more about. Billionaires who believe they want to control this political process. Do they have an agenda? Of course they do. We know it. We see it all the time. And that is what this decision process has become. And so here comes Neil Gorsuch from the 10th Circuit, who comes before us, presenting his credentials, and we get a chance to ask questions. We know he's received the stamp of approval of the Federalist Society and the Heritage Foundation. And we ask some basic questions to try to understand, is he really a captive of this special interest group? Or is he something else? And the questions we asked, I laid out my expectations in a February speech on the Senate floor, what I needed to hear in there. I asked, can you demonstrate that as a Supreme Court justice you would uphold and defend the Constitution for the benefit of everyone, not just the corporations, the privileged elite? Can you demonstrate that you will be an independent check on this president or any president? Can you show you're prepared to disappoint this president who chose you and the right-wing groups that have taken credit for your name coming before this committee? And I said, you need to be forthright about what your values are. Well, today's opening day of the baseball season a few blocks away from here, and unfortunately for those 4 questions, Judge Gorsuch went 0 for 4. He told us he wants to be judged based on his own record, not the views of Donald Trump or anyone else. Well, let's look at his record. 10 years on this circuit bench. In case after case, he favored corporations, employers, and special interest elites, the very folks who sent his nomination to this committee. He favored them over workers, consumers, people with disabilities, and victims of discrimination. He says he neutrally follows the text of the law and the original intent of the law, and yet we can find clear patterns where he bends precedent and selectively focuses on some parts of text and not on others. Alphonse Madden has become legendary in this committee. This poor frozen trucker out on Interstate 88 west of Chicago in January, 14 below, given a choice between freezing to death and sitting there and waiting as he sat and waited for a repairman, or dragging a disabled trailer out on the interstate and endangering his life and the life of others. My friend and colleague, Senator Franken, said it was an absurdity, and as he reminded us, he specialized in absurdity in a previous life. Well, in this situation, 7 judges took a look at Alphonse Madden's plight, and 6 of them said it was clear. This man did what any reasonable person should do, and he shouldn't have been fired for it. The one judge who didn't see it that way, Neil Gorsuch. The Luke P. case came out, if you recall, in the midst of our hearing in this room. The Supreme Court unanimously, an opinion written by Justice Roberts, unanimously struck down the very words written by Neil Gorsuch when it came to this poor disabled child and his education. And I have to disagree with my friend from South Carolina. He was not just applying precedent. Read the exchange between Neil Gorsuch and Senator Klobuchar. He was doing more. He was reaching into another circuit, and he was embellishing that standard with a word which clearly, as the Supreme Court found, meant that kids like Luke P. would get no education at all. Grace Wang, we didn't talk about her too much at this hearing. We should have. Professor at Kansas State University, diagnosed with cancer, facing a bone marrow transplant. She was given 6 months off for this amazing, important, and dangerous operation. She was supposed to return to the classroom at the end of 6 months, but there was an influenza epidemic on campus, and she said to the people at the university, "I'm afraid to go back. I'm very vulnerable, having just gone through a bone marrow transplant." And they said, "If you don't return to the classroom, you're fired." It was Judge Gorsuch who wrote the opinion that said that was a reasonable decision by Kansas State. I don't think it was, but I think it's a reflection on his values. NLRB versus Community Health Services. His dissent contorted NLRB precedent and authority and argued that workers who were unfairly locked out would get a windfall if they received full back pay, while also keeping their wages from second jobs. I won't go through all the list of cases. We've read them all. And they do paint a very troubling picture of Judge Gorsuch and his values. There's a clear pattern in these cases. Judge Gorsuch claims to support supposedly neutral philosophies, but somehow, time and again, they lead him to the same outcome. The worker, the victim, and the consumer lose. The corporate elite win. He's also repeatedly shown that he does not want to follow simply the law. He wants to change the law in some cases. Federal Judge John Kane came here, testified under oath in support of him, but he made a revealing comment at the hearing. He said, and I quote, "Judge Gorsuch is the only judge I know, only judge of whom I am aware," he said, "who has written both majority opinions and concurring opinions in the same case." Why would a judge do that? Consider one of the cases, Gutierrez versus Brizuela, where Judge Gorsuch wrote the majority opinion, then used a concurrence to call for abandoning the Chevron doctrine, which we spent a lot of time talking about. That's an idea that fits well with some people who want to deconstruct the modern administrative state. For reference, read Breitbart. But it would append agencies' liability to enforce important civil rights, consumer protection, and environmental laws. Gorsuch told us time and again, Judge did, about his efforts to ensure indigent defendants were appropriately represented. Look at his record. When it comes to Sixth Amendment, it's a perfect record. Judge Gorsuch's record, it's perfect. 52 opinions, Judge Gorsuch never, underline never, found that an attorney provided ineffective assistance of counsel. Williams versus Jones, his dissent would have found no prejudice for a defendant when his attorney said he would quit if the defendant didn't accept a plea deal, and then falsely told his client it would be perjury to accept a 10-year plea agreement instead of life without parole. I asked him about that case, and he still thought that that man had good representation and a fair trial, as he said it. 2 Republican appointees disagreed, and Judge Gorsuch's reasoning was later rejected by the Supreme Court in Lafler versus Cooper, when the court held that the accused must have competent guidance from an attorney in deciding whether to take a plea deal. Judge Gorsuch has provided no reassurance he'd be an independent check on this president or any president. We learned a lot about his emails at the Justice Department. I won't replow that ground, which was handled so well by Senators Feinstein and Leahy. For my Republican colleagues who never tire of bringing up Judge Gorsuch's 2006 confirmation, may I remind you of the obvious? At that time, we didn't know about Judge Gorsuch's troubling record at the Justice Department, and we certainly didn't have a decade of judicial decisions where Judge Gorsuch tilted the playing field toward big business and away from American families. The art of evasion is certainly one that is used by most nominees who come before us, but I think that Judge Gorsuch developed it to a new level. He said virtually nothing at this hearing to ease concerns many of us had about Chief of Staff Reince Priebus's declaration that Judge Gorsuch was, quote, a man with the vision of Donald Trump, whatever that means. Of course, no one has illusions about what's going on here. We know who sent him. And we know when people talk about the American Bar Association rating him unanimously well qualified, the first name that comes to my mind is Merrick Garland. If that were the standard, we wouldn't be meeting in this formal session. We'd be celebrating the first anniversary of Merrick Garland's year on the bench. But we're not. We're here because of a Republican strategy, Senator McConnell's strategy, and the rest of the Republicans to line this vacancy up for the next Republican president. There's been a lot said about the damage that may be done to the Senate with this nomination and the votes that will be taken this week. It breaks my heart to find us in this position. I love this place. I've been here for a big part of my life. And I can remember things about it as senators who are as senior as I am, and maybe more, can remember about this institution, what it used to be like, what the standards used to be, the pride we took in the Senate. But then came this onslaught of filibusters, unprecedented in the history of this body. Senator McConnell and the Republican majority at the time, even in the minority status, did everything they could to stop the orderly consideration of bills and nominations. leading to the point where the second most important federal bench in the land, D.C. Circuit Court of Appeals, was basically frozen. They couldn't fill vacancies because of the threats of filibusters for these nominations. And that's what led to this well-worn and well-discussed rules change. And that's what brings us to this point. One of my senator friends, Senator Graham, said, Senator traditions will change this week. In honesty, they started changing a long time ago. I just hope at the end of the day we can resurrect what this institution was all about and should still be all about. This nomination does not give us that chance, unfortunately. And we know what the fate of this nomination is likely to be. Mr. Chairman, I have comments on the other two nominees, but I thought at the outset you were going to ask us to withhold those statements on Rosenstein and Bland.
I'm going to. You don't have to, but I'm going to.
Well, at the risk of going on, and I won't go on, I'll put the statement in the record. At Rosenstein's hearing, I was impressed by the fact that this man survived Republican and Democratic presidents and was U.S. Attorney. He certainly comes with high recommendations from our senators from the state of Maryland. I was troubled when he said he hadn't read the intelligence community assessment on Russia's interference in our election. He responded to my March 13th letter on the subject, confirmed he's now read the report, and he, quote, had no reason to doubt the intelligence community's assessment. I thank him for that. He also clarified the recusal of Attorney General Sessions, and I thank him for that. He would still bear responsibility for this Russian the Justice Department investigation into Russia's cyber war against the United States. I hope he'll appoint a special counsel for that purpose. He also will have responsibility over criminal justice efforts at the Department of Justice, and I'm concerned about the sentencing guidelines which Attorney General Sessions has now suggested. I'm going to vote to report him out of committee, withhold my final vote on the floor until there is some clarification about a development this week. Stephen Cook, the former president of the National Association of Assistant U.S. Attorneys, has been tapped as a Deputy Attorney General and top deputy on criminal justice policy. The media report says, quote, meet the hardliner Jeff Sessions picked to carry out his violent crime crackdown. Steve Cook, a former federal prosecutor, fiercely supports controversial policies calling for lengthy prison sentences, end of quote. Members of this committee will remember Mr. Cook from his 2015 testimony, stridently opposing the bill which the chairman of this committee and I support, the Sentencing Reform and Corrections Act. On Ms. Brand, let me say again as briefly as I can, I believe that I have to oppose her for three reasons. She spent much of this decade working as chief counsel for the U.S. Chamber. When I asked her if she would recuse herself from matters involving the Chamber, she would not make that commitment. We need that assurance before I can vote for her. Second, I'm concerned about her refusal to answer key questions about civil rights, and I'll put those in the record for reference. Third, Ms. Brand refused to say whether man-made climate change is real, whether there's a public interest in addressing it. Troubling for a person who would oversee the Justice Department's Environment and Natural Resources Division. I will assure Ms. Brand that she'll be treated better than President Obama's nominee for Associate Attorney General Stuart Dellery, who was never given a floor vote by the Senate Republicans. Ms. Brand will get her vote, but I will vote no. I yield the floor.
Your statements will be put in the record. Senator Cornyn.
Thank you, Mr. Chairman, for the way you've conducted these hearings and this markup and given everybody a chance to express themselves. In listening to our colleagues across the aisle, I can't imagine the pressure that they're feeling to oppose this nominee. But if they're going to oppose Neil Gorsuch to the Supreme Court of the United States, they will never vote and never support a nominee of this president. Because in the end, I think that's really what gets their goat the most. We keep hearing about Merrick Garland, but I guarantee you, if Hillary Clinton had won the presidency, we'd never hear Merrick Garland's name again, because she would have had the opportunity to pick her own nominee to the Supreme Court. And the chairman's exactly right. We essentially made this presidential election on November the 8th a referendum on which of the candidates do you want to pick the nominee for this, to the Supreme Court to fill the vacancy left by the death of Justice Scalia. And the American people answered that question and said they preferred President Trump to make that selection as opposed to a potential President Hillary Clinton. So I do not envy our colleagues who know they have a qualified, honorable, good public servant in this nominee. Judge Gorsuch is an outstanding choice by the President, and given the circumstances, indirectly by the American people. I'd urge my colleagues to recognize those obvious realities and support the nominee. Failing that, I'd encourage them at least to give this nominee an up or down vote on the Senate floor. Let me go back and just cover briefly some of the criticisms of the nominee. First, our colleague said that, well, the judge won't give me an answer to a hypothetical question about how I might rule on a future case. But they well know that every Supreme Court nominee has appropriately refused to answer those kinds of questions. How would you feel as a potential future party to a lawsuit in a judge's court if that judge has already told you how they would rule before you had a chance to present your case? Well, you wouldn't feel like justice was being done, and it's not. That's why judges routinely refuse to answer questions about how they would vote and how they would render judgments in future cases. We saw that from Justice Sotomayor. We saw it from Justice Ginsburg. All of the judges who've come before the committee have held to that same standard. So that one clearly doesn't hold water. Well, like I said, we've heard a lot about Merrick Garland, but I doubt we'd hear anything about Merrick Garland again if Hillary Clinton had won, and I'll leave it at that.
Jennifer.
Then they complain about outside groups, the Federalist Society, other nefarious organizations, supposedly, that are exercising their rights under the Constitution to speak freely and to support a nominee who they believe will faithfully execute the duties of the office. How outrageous. How outrageous that somebody would actually have the freedom to advocate on behalf of a nominee to the Supreme Court. I tell you, the alternative that our colleagues suggest is not the kind of America that I want to live in, one where the government decides who gets to speak and who does not get to speak. Our colleagues may not remember, but I remember Judge Gorsuch talking about the 1958 case called NAACP versus Alabama. There, Alabama sought to get the membership list of the NAACP. For what purpose? Well, you can guess for what purpose. What did the court hold? The United States Supreme Court said that under the First Amendment to the Constitution, you have a freedom to associate with anybody you want to. And that if the government's going to use that information to intimidate you, to prevent you from that freedom of association, well, that violates the Constitution of the United States. All we hear from our colleagues is about dark money, unidentified contributors. Well, there was $5 billion spent by Hillary Clinton, Donald Trump, and their friends in the last election. $5 billion, and you're saying that the $10 million that's being spent on this nomination is somehow influencing how people will vote? It's just ridiculous. Well, let me repeat or maybe restate in a little bit different way some of what Senator Graham and others have said about how we find ourselves here. There has never been a partisan filibuster of a Supreme Court nominee in American history. Never. This will be the first. Sometimes people want to talk about Abe Fortas in 1968. Well, that was a bipartisan failed cloture vote. The judge, 4 days after his nomination was on the floor, asked that his name be withdrawn and ultimately resigned in disgrace because of ethical lapses. That's not precedent for Neil Gorsuch. That's just an excuse. Well, I dare say that if Judge Gorsuch is unacceptable to our Democratic colleagues, there will never be a nominee by this president that you will find acceptable. Never. How did we get started with filibusters of judges? Well, we know there was never a partisan filibuster of a judge to the Supreme Court before this one. And actually, it was an innovation of our colleagues across the aisle back after the 2000 election. There was a famously reported meeting of people like Lawrence Tribe and Chuck Schumer and other liberal activists who figured out, well, George W. Bush won the election. How can we stop his nominees for judge from getting confirmed? And they dreamed up this idea that, well, we can say that instead of a majority vote, which we all thought the Constitution required, that we can say you can't get confirmed unless you can get 60 votes. In other words, that the Senate rules somehow preempt the Constitution itself. Well, that precipitated quite a crisis in the Senate. I recall Senator Graham talked about it. Ultimately, there was a group, bipartisan group of senators, the so-called Gang of 14, had entered into an agreement that saw most of the president's nominees being confirmed, and I think 2 of them not confirmed. So that's how we got started down this path of filibustering judges. It was our Democratic colleagues after the election of 2000 when they wanted to stop the nominees of George W. Bush from becoming confirmed. What was the next iteration of that? Well, after they cooked up this idea, in 2013, they found it to be an impediment to their desire to pack the D.C. Circuit Court of Appeals, the court that had primary jurisdiction over the administrative state during the Obama administration. And it was a bald power grab. The sole purpose of it was not to fill the bench with people where they were needed in so-called judicial emergencies because people were backed up and couldn't get a hearing in court because there weren't enough judges. No, this was probably the least hard-working circuit in the country, yet they sought to pack the D.C. Circuit Court of Appeals for no other apparent reason other than to rubber stamp President Obama's administrative state. We didn't like that very much, to say the least, but that was the latest iteration, and now we've apparently come full circle. 2017, never before a partisan filibuster of a Supreme Court nominee until this one. And our colleagues say, well, this is going to be the end of the Senate as we know it. No, this will merely return us to the status quo before they erected this 60-vote requirement during the administration of George W. Bush. Theoretically, you could filibuster judges, but it just didn't happen. Clarence Thomas was confirmed with 52 votes. There wasn't even a vote on cloture. No threat of filibuster. So we come full circle, Mr. Chairman. Some say that, well, when we confirm Judge Gorsuch, somehow that will be the death of the legislative cloture requirement. But I would just remind our colleagues that we treat nominations and legislation very differently for a good reason. The Senate is supposed to be the cooling saucer when it comes to legislation passed by the House of Representatives. And that's an important role, particularly when you're legislating for 320 plus million people. But when the question is up or down on a nominee, you can't change that by amendment. There isn't any consensus building. You have a binary choice, yes or no. It's a far different issue. So I disagree with those who somehow say this is the end of the Senate as we know it. This is a restoration of the status quo ante. before our Democratic colleagues erected this artificial 60-vote requirement. So I'm proud to say that this good man and this good judge who's offered himself to serve our country on the United States Supreme Court will be confirmed by the end of this week, and he should be.
Senator Whitehouse.
Thank you, Chairman. Let me join my colleagues in expressing my appreciation to you and the staff for the wholesome and collegial way in which you've conducted this hearing. And let me say that there is actually another way to do this. Nothing prevents a president from announcing a consensus nominee for the Supreme Court with both Senate leaders standing beside him. Nothing prevents that. This president chose to go a different way, choosing a candidate off lists put together by what I consider to be front groups for big special interests. And there's a significant backdrop to that concern. Let's go back to 1954, for starters, when in his first year on the bench, Chief Justice Earl Warren was faced with the monumental case, Brown versus Board of Education of Topeka, Kansas. Earl Warren knew that the court had to finally answer Justice Harlan's call in Plessy and finally strike down school segregation across the country. Drawing on his experience in politics, Chief Justice Warren also knew that such a far-reaching decision needed unanimity among the justices on the court. And the Chief Justice worked through draft after draft of the opinion until he had forged that essential consensus. This example of consensus building appears to be lost, starting under Chief Justice Rehnquist, but increasing under Chief Justice Roberts. The conservative appointees on the court consistently deliver for the Republican Party and big business in a recurring and disturbing array of 5-4 decisions. Those decisions, when you look at their analysis, have been anything but conservative in the judicial sense. They overturn precedent, they toss out statutes passed by wide bipartisan margins in Congress, they ignore original meaning, and they stretch to reach constitutional issues. Rather than calling balls and strikes or working to develop narrow rulings that do in fact build consensus, when there are 5 Republican appointees on the court in recent years, they have consistently delivered 5-4, a bigger strike zone to Republicans and to big business. In elections, in a 5-4 decision in Veith v. Jubileer, the court held political gerrymander claims were not reviewable, paving the way for the red map statewide gerrymandering project that gave Republicans control of the House against the majority vote of the country in 2012. In Shelby County and in Bartlett v. Strickland, again, both 5-4, the conservatives knocked down protections of the Voting Rights Act, allowing Republican legislatures to target minority voters with what the Fourth Circuit later called surgical precision. 3 more 5-4 cases, Citizens United, Bullock, and McCutcheon, gave unprecedented political power to big Republican donors as the Republicans on the court unleashed what has been described properly as a tsunami of slime on our American elections, throwing our political system into chaos and very predictably advantaging powerful Republican political interests. 6 5-4 decisions affecting the political balance of American elections. 6-0 is the score for Republicans. On to big corporations. Corporations hate being hauled in front of juries. Juries are the one institution designed by the founders to be most immune to power. the institution of the jury was a particular favorite, a cause even, of the Founding Fathers. But in 5 decisions, Iqbal, Walmart v. Dukes, Comcast, Concepcion, and Italian Colors, all 5-4, this court insulated corporations from being held accountable by American juries. And by the way, those decisions made no mention of the 7th Amendment. Their decisions helped insulate investment bankers from fraud claims, Janus Capital Group, 5-4. They protected employers at the expense of employees bringing discrimination cases, Ledbetter, Gross, Vance, and Nassar. 4 decisions, all 5-4, all holding for the corporate employer. They hobbled unions in cases like Harris v. Quinn, 5-4, and I don't think it takes a crystal ball to guess the outcome of the Friedrichs question when it comes back up to the court with a 5th Republican justice. Then come the bonus decisions. Hobby Lobby asserting that corporations have religious rights that supersede health care rights of their employees, 5-4. And Heller and McDonald reviving for the gun lobby and firearms manufacturers a theory a former Supreme Court Chief Justice once called a fraud, 5-4, all Republicans. Add back in those 3 pro-corporate political spending cases, and the score on this count, corporations versus humans, is 18-0. At some point, a pattern becomes evident. It is against this evidentiary backdrop that I reviewed Judge Gorsuch's nomination. He had to prove to me that he would not join a new right-wing gang of 5 upon joining the court and go on another similar corporate shopping spree. I am sorry to say he did not meet that bar. I know my friends on the other side of the aisle will accuse Democrats of being unreasonable and politicizing this process. Indeed, they already have. This is a bit rich to us, coming from the party that not only denied Judge Garland, perhaps the most qualified judge ever nominated so much as a hearing, but from the party that has been the flagrant beneficiary of all these partisan decisions. I feel like I'm watching Casablanca, where the inspector says that he is shocked to find that gambling is going on here, as he is handed his winnings. I believe we are nearing a break point for the court and for the country. Since Citizens United, faith in government has dwindled and cynicism toward government has skyrocketed, exactly as certain forces would like. In a 2015 poll, 75% of U.S. adults perceived corruption as widespread in the country's government. 75%. And 82% of Americans think money has too much influence in politics. By the way, they're right. Even the Supreme Court is not spared from public disillusion. By a margin of 9-1, Americans think a regular person won't get a fair shake against a corporation in our Supreme Court compared to vice versa. And the 3 major popular writers on the Supreme Court all express similar concerns. Something is wrong at the court. As a child of the Foreign Service, I grew up a firm believer in American exceptionalism. I saw firsthand what happened when dictators or oligarchs could manipulate a government for their own gain. The incessant danger to popular democracy at the hands of concentrated economic power was warned of long ago by none less than Thomas Jefferson, who warned of what he called a trial of strength between popular democracy and moneyed corporations. Americans need a justice who understands these stakes. Americans need a justice who can help the court find its way back to robust protection of popular democracy and not so relentlessly take the sides of moneyed corporations in that Jeffersonian trial of strength with popular government. For this nominee to be unable to say, for instance, that dark money is a plague on our democracy is, to me, disqualifying. That silence is particularly pungent while the beneficiary of a dark money campaign for his confirmation. This nominee's candidacy was born on a list prepared by right-wing pro-corporate front groups, was announced to this nominee by the leader of one of those groups, and is supported by millions of dollars in dark money spending. Against that backdrop, his silence on dark money is telling. And the political leader of the Republican Party is preparing to break the rules of the Senate to guide him onto the court. Please don't tell me that he is making that effort in the interest of some high judicial philosophy. This is about making sure that people win at the court who are of a certain type, like CEOs and billionaires. I'm sorry, but there is just too much evidence of where this leads for me to trust this nominee. I yield back.
Senator Leahy.
Thank you, Mr. Chairman. Fortunately, our system doesn't require us to trust any one person. What we trust is the law. What we trust is the Constitution. What we trust is a system which, if properly followed and administered, will result in the equal application of the law to the individual. What we've seen here today from many of my colleagues is an explanation as to complaints that different people have about Judge Gorsuch. Complaints that, because they're not directed at the way he actually analyzes the law, try to blame him for something else. Try to blame him for something other than his jurisprudential approach. Try to blame him for something that has resulted either from the conduct of a third party, someone not being considered for confirmation to the United States Supreme Court, or blame him, in some cases, for the law. Laws that are actually made by Congress, or in other instances, precedent set by the 10th Circuit that he has followed faithfully in individual cases. So there's been a suggestion. Sometimes it's been implicit, other times it's been very explicit, that Judge Gorsuch is beholden somehow to individuals that have expressed support for him. This is a very, very serious claim. But there's absolutely zero evidence to back it up, not a scintilla of evidence. This is not how Judge Gorsuch decides cases, and there's nothing there to back that up. And yet my colleagues, many of them have continued rather recklessly to accuse Judge Gorsuch of being someone who is influenced on the basis of someone's identity as a party, on the basis of whether they're an individual or a corporation, a big guy or a little guy, as some of them have put it. And yet there simply is no evidence for that. And to suggest otherwise, to suggest that that has been happening, that has happened on the 10th Circuit with Judge Gorsuch's rulings, that it has happened on the Supreme Court, you might as well call a judge with whom you disagree a so-called judge. This is denigrating to our judicial system, which, while imperfect, is one that I would put on par with, and in fact above that of any in the world. Now, several members of this committee have gone so far as to sign a letter asking Judge Gorsuch to find out who funds one of these organizations in particular, called the Judicial Crisis Network, and then also to recuse himself, if he's confirmed to the Supreme Court of the United States, from any cases involving that organization or those who fund that organization. This is an odd request. In fact, it's unprecedented. And it's one that I would add is unnecessary. As Judge Gorsuch pointed out, no one else speaks for him. No one else is authorized by him or anyone else to speak for him. He speaks only for himself. And in fact, this is by design. This is why the Constitution was written the way it was. It's why we give Article III judges, including Supreme Court justices, life tenure so that they can serve without any risk of outside influence. But the request is most definitely unprecedented when it comes to this committee. Whenever there is a Supreme Court nomination, a number of organizations will submit papers to this committee. Some will submit testimony, others will submit letters. Some of them might run advertisements. In short, people exercise their First Amendment rights to weigh in on a particular nominee. And yet, to my knowledge, based on what I've been able to discover until now, the committee has not asked a nominee to exert public pressure on any outside organization, has not asked any nominee to the Supreme Court to tell any organizations happening to speak on that nominee's behalf or purporting to advocate for the confirmation of that nominee, to out that organization's donors, to identify them. That's not the nominee's job. That's putting the nominee in a terrible position. So I'd like, Mr. Chairman, to enter for the record a list of organizations that submitted letters in connection with the nominations of Justices Kagan and Sotomayor. They're very long lists spanning
Without
several
objections to
pages.
order.
Thank you, Mr. Chairman. In addition, I'd like to note that there were a number of other groups that have, over time, expressed their viewpoints in one way or another as to their support or opposition to various Supreme Court nominees. Many of these have been on the left. Many of these have been from organizations like, including NARAL, NOW, Move On, People for the American Way. And yet, I'd note that no member of this committee, not a single Republican, not a single Democrat, has suggested that a nominee has any obligation at that point either to identify such organizations' donors or to recuse oneself from any case involving one of those organizations or anyone contributing to those organizations. Not one. Not in the case of Justice Kagan, not in the case of Justice Sotomayor, not in the case of any other Supreme Court nominee I'm aware of. I also want to say another thing about this dark money point. Some of my colleagues have characterized this as the natural outgrowth of Citizens United. And this is not the outgrowth of Citizens United. In fact, this line of reasoning ignores the fact that the Supreme Court upheld the FEC's disclosure rules in Citizens United by a vote of 8-1. It ignores that lower courts have used that part of the decision to uphold other disclosure requirements. It ignores the fact that in 2010, in a different case called Doe versus Reed, the Supreme Court upheld other disclosure requirements. So if you have issues with lack of disclosure as mandated by federal law, perhaps we should talk about that in connection with the legislative discussion. If you want to change the law, let's talk about changing the law, but make sure that you're not blaming something on the Supreme Court that the Supreme Court didn't do. And you certainly shouldn't blame something on Judge Gorsuch that Judge Gorsuch didn't do, especially to the extent you're talking about setting federal policy, about making federal law. That, after all, is Congress's job. And the inadequacy of the law there has to be pinned back on us, not someone else. I also want to address this notion that somehow there is a big guy, little guy dichotomy that we need to be worried about, that Judge Gorsuch is opposed to the little guy and always favors the big guy. Well, it's worth noting something that Chairman Grassley alluded to earlier. There was a statement made by Professor Noah Feldman, a professor of law at Harvard, himself a self-described liberal law professor at Harvard, who referred to this attempt to smear Judge Gorsuch as, quote unquote, a terrible idea. That was the portion of the statement that Chairman Grassley quoted earlier. I'd like to share a little bit more of that statement, where after explaining that it's a terrible idea, he goes on to explain some of the reasons why, including the fact that Siding, quote, siding with workers against employers isn't a jurisprudential position. It's a political stance. And justices, including progressive justices, shouldn't decide cases based on who the parties are. They said they should decide cases based on their beliefs about how the law should be interpreted, close quote. So Professor Feldman, again, himself a self-described liberal, is right. This is a bedrock principle in the rule of law and in the American legal system under our Constitution, that judges don't. In fact, they should never decide cases based on the identity of the individual parties. That's not how it works. It's not ever how it should work. It's one of the reasons why, as Judge Gorsuch has so carefully explained, that you show me the rulings of a judge who always agrees with his or her own decisions, always feels comfortable with them as a matter of policy outcomes. And I'll show you someone who's not a very good judge. His judges aren't there to decide cases on the basis of the identity of the parties. Now, if you think Wong or Luke P. was wrongly decided, or if you think Judge Gorsuch's separate opinion in Trans Am trucking was wrong, then make a legal argument. Make a legal argument. Let's talk about the text, about how the statutory text in that case was interpreted. That's the appropriate discussion to have here. If you're worried about the driver in the Trans Am trucking case, let's talk about statutory construction rather than talking about the outcome. If you want me, or if you want Judge Gorsuch, if you want anyone to defend whether or not the law was written in that case, well, that's a different equation altogether. That deals with Congress. That's our fault. If what you want to do is talk about whether or not the employer made the right decision to terminate the driver in Trans Am trucking, I don't think anyone in this room is going to do that. As far as I can tell, it was a foolish decision to fire that trucker. I don't think Judge Gorsuch, were he to opine on that, would disagree. But that wasn't the question before him. The question before him was whether federal law had something to say about whether or not that decision could be legally upheld. The law, as he very carefully analyzed it, would not allow judicial intervention in that circumstance, and that is exactly the kind of jurist we need. Now, again, if you disagree with his legal analysis in that case, let's talk about it in terms of his legal analysis, rather than on the basis of the identity of those parties. Everyone on this committee is familiar enough with the law and the cases to do that. I can only assume that in instances where people can't identify enough of a statutory textual reason to disagree with them, perhaps they want to change the subject to something else, and so they turn to the identity of the parties. In any event, these are a few cherry-picked cases out of 2,700 cases that Judge Gorsuch has decided in his 10 years on the bench. They ignore cases where Judge Gorsuch has sided with the little guy, cases like Gutierrez-Brizuela versus Lynch, cases like AM v. Holmes, Fisher versus City of Las Cruces, Orr versus City of Albuquerque, Williams v. WD Sports, and Walton v. Powell. I'm wondering why these cases don't count, why these don't somehow tally up. I wonder why, in arguing that Judge Gorsuch is somehow out of the mainstream, how a judge that is so wildly out of the mainstream that he can't be confirmed to the Supreme Court of the United States could have, in 2,700 cases, spanning an entire decade of judicial service on the U.S. Court of Appeals for the 10th Circuit, have been, how that same person who was so out of the mainstream could have been 97% of the time in a unanimous posture with the colleagues on his court, remembering, of course, that as an appellate judge on the 10th Circuit, he never sits alone. He's sitting always in a panel, usually a panel of 3 judges, sometimes in an en banc posture where he sits with a dozen or so of his colleagues. So in 97% of the cases, he reached a ruling that was unanimous with his colleagues with whom he was sitting. In 99% of the cases, he was in the majority. That is not the background of a judge who's out of the mainstream. If you don't think Judge Gorsuch should be confirmed, focus on his jurisprudential approach. If you disagree with some of his rulings, focus on his legal analysis.
That's going to be a problem for us.
At the end of the day,
We're going to have to figure
it's difficult to imagine a judge who is more well-prepared, more well-credentialed, or more well-suited as a matter of judicial interpretation, of statutory construction, a matter of judicial temperament.
what he's saying is
I'm honored to support the confirmation
his verdict.
of Judge Gorsuch and I encourage my colleagues to do the same. Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you very much, Mr. Chairman, and thank you.
Say, before you go, and your time won't start, hey, I want to consult with you as I did my ranking member here. There's two ways we can do lunch. We can adjourn from 1 to 1:30 or approximately that time, or if you're willing to do it and people go one by one and go eat, I'm willing to stay here and plow right through until we get done. Could I have some sort of a consensus of what to do? Maybe if you want to adjourn from 1 to 1:30, raise your hand.
Well, could the majority cater lunch?
Okay, and people that don't want to do that, stay here.
I vote for plowing right through, Mr. Chairman.
Yeah.
Yeah, I think we should plow right through, yes.
You
Plow right through regardless of the catering issue.
well, okay. I asked for, actually the people that wanted to adjourn for a half hour had the most votes, but
Oh, okay.
Since let's
Can't even agree on
Well, Mr. Chairman, may I ask a question about that?
Yeah.
Is the goal to finish the
yeah, we
speeches
have
today?
to finish today.
Okay.
Yeah. And we will be able to because we've been told that there won't be the 2-hour rule won't be invoked and all that stuff, so we'll be get done. Okay, then we'll just plow right through. Senator Klobuchar, go ahead.
Okay, thank you. That was a great beginning to my fine oratory here. I want to actually take on Senator Lee's challenge here to focus on the nominees' judicial philosophy. And I will say a few things. First of all, I want to thank the chairman and Senator Feinstein for how they conducted the hearings. I thought they were civil, and I think that was really important, especially with what we're dealing with now. And I also was thinking it is true that for most judges, there's agreement on a lot of the easy cases in the lower federal courts, but those aren't the cases that the Supreme Court gets. The Supreme Court gets those hard cases that are in the gray area. And so for me, as I've looked at the nominee's record, I've tried to focus on when he was confronted with cases that he could deal with on the Supreme Court, like campaign finance, which we know has been a major decision that's come out of the Supreme Court. How has he responded to those kinds of cases, and what do we think he would do when he got on the Supreme Court? And what I've concluded is and maybe the best analogy is you, Senator Lee, when you and I work on these antitrust matters and we try to find common ground, we have many different views on them, and then we try to find the area where we have consensus, that narrow ground where we have consensus, and we're able to come together at that moment. Well, there are many of the nominees' opinions where that's not what he did. He might be on the opinion where there was consensus, but then he tries to go a step farther and take kind of, in my mind, a provocative approach, a broad ideological leap. And that is what concerns me when you get to the Supreme Court level. With some of my other colleagues, I have sat through the last hour here, and do I find it difficult to hear them spout righteous indignation about the Senate rules? I do, because when I hear the litany of those votes for those other nominees, 97-0, 98-0, the numbers for Justice Kagan, the number for Justice Sotomayor, the numbers for Justice Roberts, the numbers for Justice Alito, all I think about is the numbers for Justice proposed Justice Garland or Judge Garland, 0. He got 0 votes because this Senate and the majority decided to sit on it for almost an entire year, something that we had not seen where a Senate did not take action on a nominee in that way since the Civil War. And so I would prefer to take Senator Lee's challenge and focus not on that today, but instead focus on this nominee himself. And after thorough examination and consideration of his answers and the record, I have decided not to vote in favor of the nominee. For me, his record on critical cases involving the rights of children with disabilities, campaign finance, and preserving health and safety protections have led me to conclude that I can't support the nomination. Now, let me make this clear. I did not expect that I would agree with every opinion he wrote and everything he ever said, but what I saw time and time again was a judge that clearly demonstrated the contrast between two judicial approaches. One is the one that we have seen with the proposed nominee last year, Merrick Garland, which was to write narrow consensus decisions. And the other is to move toward more ideological decisions. And I saw a lot of those ideological decisions in key cases. Now, Senator Durbin mentioned this disability case, and I was the one that asked a lot of questions about that case after Senator Durbin initially raised it, since the Supreme Court decided on the day we had the hearing for Judge Gorsuch, decided on an 8-0 decision to reject what was essentially the standard that Judge Gorsuch had come up with in a case a few years back in the 10th Circuit. Now, as we know, the IDEA, very important for parents of kids with disabilities and for kids with disabilities. In my state, 124,000 kids rely on this law to protect their education. I also am quite aware that I occupy the Senate seat that was once held by Minnesota's own Hubert Humphrey. He was someone who, of course, was never at a loss for words, and he delivered a speech 40 years ago in our state. And the line of that speech that's just as appropriate as it was then, I think, is appropriate today. And he said, quote, "The moral test of government is how that government treats those who are in the dawn of life, the children, those who are in the twilight of life, the elderly, and those who are in the shadows of life, the needy, the sick, and the disabled." So in an 8-0 decision just 2 weeks ago, the Supreme Court honored that principle, ruling against a narrow interpretation of the IDEA embraced by Judge Gorsuch that limited the educational opportunities of kids with disabilities. Chief Justice Roberts wrote the unanimous opinion and rejected the merely more than de minimis standard that the judge used to limit the help that children with disabilities can get at school. I couldn't agree with the 8-0 decision more. All children, particularly those with disabilities, deserve the tools they need to succeed in life. And every justice on the Supreme Court has a duty to protect those kids. They're simply following the words that are actually etched on the Supreme Court building: equal justice under law. In explaining his ruling, the judge said that he was bound by precedent to use the merely more than de minimis standard. I sat here today as Senator Graham repeated those words, and he said, well, the judge was bound by precedent. So I spent a lot of time looking at that to see if, in fact, that was true. And I simply don't agree when you look at the cases. So what happened was, back in 1996, before Judge Gorsuch was on the 10th Circuit, there was a case about a kid with a disability. And the 10th Circuit made a number of findings, but when they talked about this particular standard, that wasn't why the case was decided. It's something called dicta. And I know I'm in the weeds here, but I am taking on Senator Lee's challenge to actually talk about the record and what it says. So what that court did way back in 1996 was they used a case from the Third Circuit that they weren't bound by and just mentioned it. They also mentioned a 10th Circuit case that they would be more bound by, which was different and was a broader standard. And then they really didn't decide the case based on it anyway. So here comes Judge Gorsuch then in 2008, and he has a case that is going to turn on this. He cites this case from the past and uses it to support this standard that this case does turn on. However, that old case, it wasn't even what it was decided on, and it was from another circuit that circuit wasn't bound by. It may be in the weeds, but it matters because it shows again that he went a step further. Was that enough? No. The old case that it cited from a way different circuit that it wasn't decided on actually said more than de minimis. As I said during the questioning, that means something. More than de minimis, if you have a gas tank that's on empty and you say more than empty, it can mean a long way up. He added the word merely more than de minimis, which clearly has a different meaning, which puts it even closer to empty. That's why I don't believe that he was, one, bound by precedent, and even if he was, which he wasn't, he changed it to add the word merely. So I just hope my colleagues just don't freely say that this was an example of someone just being bound by precedent. No, it wasn't. It was an example of someone that made an opinion. Maybe it's well written. Maybe some other people agreed to it. I don't care, because those other people, they're not up for a Supreme Court justice. He made this decision, and he went again farther than he needed to, which is my common theme here today. Second, campaign finance. In my view, one of the most troubling court decisions in recent years is Citizens United. Since Citizens United, dark money, as my colleagues have pointed out, has been spent in extraordinary sums, adding up to an estimated $800 million in just the past 6 years. It continues to have an outside influence on our politics, distorting our representative democracy, hurting, in my mind, our campaigns on both sides of the aisle. You can't control who you are to the people you represent and what they say about you if, in fact, other people are doing it for you, other groups that you have no control over. Now, how does this apply to the judge? It applies to the judge. I wouldn't even be bringing it up if he hadn't made a decision that was very relevant to this area of the law. So there was a case that came by Riddle v. Hickenlooper, and it was a narrow case about how the campaign finance laws apply in Colorado to certain kinds of contributions involving major parties or non-major parties. But was it enough just to be in that narrow consensus group? No. He then issued a concurring opinion, which went farther. And what he said was maybe we should apply strict scrutiny laws to restrict campaign contributions. What does that mean? Well, if the Supreme Court adopted Judge Gorsuch's view, it would compromise the few remaining campaign finance protections that are still on the books, and it would make it even more difficult for Congress to pass future reforms. The notion that Congress has little or no role in setting reasonable campaign finance rules is in fact in direct contradiction with where the American people are. In recent polls, over 3/4 of Americans have said we need sweeping new laws to reduce the influence of money in politics. Now, while polls aren't a judge's problem, democracy should be. When unlimited, undisclosed money floods our campaigns, it drowns out the people's voices. It undermines our election. It shakes the public's trust in our process and in those words etched on that Supreme Court building: equal justice. My colleagues and I asked the judge again and again about his views on our campaign finance laws and public disclosure requirements. He had many opportunities, but he never told us what a proper legal standard for evaluating campaign finance laws would be if he wasn't going to use the one that's been used. A majority of our current justices support public disclosure of campaign contributions, and yet the judge gave us no real sense of his views. During our exchange on campaign finance, I was reminded of the words of none other than Justice Scalia and his support for greater public disclosure. Scalia said this: requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed. For my part, I do not look forward to a society which thanks to the Supreme Court, campaigns anonymously and even exercises the direct democracy of initiative and referendum, hidden from public scrutiny and protected from the accountability of criticism. This does not resemble the home of the brave. That's campaign finance. Third example, Chevron. The most striking example of a decision made by the judge not to decide a case narrowly based on the facts was this one, in which he actually wrote the opinion and then wrote a concurrence to his own opinion. That's pretty different than what most judges do, because they mostly embrace the fact that they've gotten a consensus opinion. I guess it's better than dissenting to your own opinion, but he did a concurrence to his own opinion, and he went beyond the facts to suggest overturning a long-established precedent in a case called Gutierrez, where he suggested eliminating Chevron. He said it was time to take on the behemoth. Chevron, as my colleagues know, is a 33-year-old Supreme Court case that ensures that the most complex regulatory decisions are made by the experts who are best equipped to handle them, not by judges or lawyers without any relevant technical knowledge. It is a standard that was, in fact, again, embraced by Justice Scalia and has been used in more than 13,500 decisions. Chevron ensures that the federal rules that health, safety, and education rules stay on the books. These rules protect the hard-earned pension money of an hourly Minnesota grocery store worker. That was an actual case in the 8th Circuit based on Chevron. They protect the clean water in our Great Lakes, and they are the difference between life and death for Minnesota iron ore workers. The judge's approach to the law would have titanic real-world implications on all aspects of our everyday lives. When he wrote an opinion that said it might be time to, quote, face the behemoth, he suggested a change in law that would put countless rules in jeopardy, compromise protections that matter to the American people, and create widespread uncertainty in our laws. I asked the judge whether he believed that overturning Chevron would create tremendous uncertainty. I asked him what he would replace it with. I did not get a straight response, and he even answered that he didn't know what all the consequences would be, and, quote, wasn't thinking about being a Supreme Court justice, end quote, when he was writing the decision. So what does all this mean? It means that the judge has repeatedly gone beyond the facts of the case, issuing separate concurrences with far-reaching effects, or, as in the case of the disability decision, actually writing opinions that have profound consequences. That is what happened. And by the way, Chief Justice Roberts, what did he say about that? He said, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. When I read these opinions, I think about Justice Byron White, who I know Judge Gorsuch clerked for and greatly admires. Justice White has been described by many as a justice who is focused on deciding only the case in front of him. Here's a quote. Time and again, Justice White avoided broad theoretical basis for a decision when a narrow, fact-specific rationale would suffice. You see, there's a reason we have judges to apply the law to the facts. It's because answers aren't always as clear as we would like. And sometimes there is more than one reasonable interpretation. And by the way, when it gets to the Supreme Court level, it's not those 97% of cases where everyone agreed at a lower court level. It's going to be those really hard cases. And it's that discretion that makes it so critical that justices interpret the law evenly, without fear or favor, and with the good judgment and humility to recognize the gravity of the office, to respect the role of the judiciary, and to understand the impact of their decisions on people. As I noted in my opening statement, and as I look back at the judge's record and his answers last week, I'm again reminded that it isn't a law professor or federal jurist who's helped by the Eighth Circuit reliance on Chevron deference in interpreting a Labor Department rule. In this case, it was an hourly Minnesota grocery store worker who got to keep his hard-earned pension. And when the court stripped away the rules that opened the door to unlimited super PAC spending, it wasn't the campaign financiers or the ad men who were hurt. It was the grandma in Lanesboro, Minnesota, who thought it mattered when she sent her senators $10 in a campaign contribution. And as the granddaughter of an iron ore miner, I can tell you it wasn't a CEO or a corporate board chair whose life was saved by the mining safety rules. It was the Minnesota iron ore workers who, like my grandpa, would go down 1,500 feet every day in a cage with their black lunch buckets, all with the hopes that maybe their kid could go to school. Those were the people. We can smile, we can talk about the rules here, but those are the people affected by the Supreme Court of the United States. My dad, who ended up as the first kid in his family to graduate from high school and from there went to community college and then to the University of Minnesota, still remembers as a little boy standing in St. Mary's Church and seeing the caskets of those iron ore workers laid out in the front of the church because they didn't have safety rules that protected those workers back then. So I believe that we need justices who understand that the law is more than a set of dusty books in the basement stacks of a law library. It's the bedrock of our society. And above all, we need justices who understand and will uphold the motto on the Supreme Court building to help all Americans achieve equal justice under law. That's why I will not be supporting Judge Gorsuch's nomination to be an Associate Justice of the Supreme Court. Thank you, Mr. Chair.
Senator Sasse.
I appear to have a defective microphone. I can be loud enough. Mr. Chairman, I have a lot to say, but I'm going to...
Can you move the microphone?
Mr. Chairman, I have a lot to say, but I'm going to save it for the floor and try to help push your schedule forward. I'd like to associate myself with your opening comments. I think it's obvious that the Senate is not a healthy institution. That is not something because of the last 6 months or 2 years. It's a long time in coming, and I'm sad about that. But bigger picture, today is a good day for America. Baseball is back, and Judge Gorsuch is one step closer to taking his seat on the Supreme Court. Thank you, Mr. Chairman.
Thank you, Senator Sasse. Senator Franken.
Thank you, Mr. Chairman. I want to compliment you and the ranking member for how these hearings were conducted, but more you.
Thank you.
But also the ranking member. Since Justice Scalia's passing, I've heard a number of my Republican colleagues, including my friend Senator Graham, this morning make reference to what is often referred to as the Biden rule in justifying their decision to deny President Obama's nominee a hearing and to keep Justice Scalia's seat vacant. This is a rule they believe then Judiciary Committee Chairman Biden laid out during a 90-minute speech. It was Biden that he gave in June of 1992. Now, then Chairman Biden did lay out a rule in that speech, but my colleagues focus on the wrong part of the speech. Because further into the speech than that which was quoted by Senator Graham, Biden said, and I quote, "If the President," and that was George H.W. Bush at the time, "consults and cooperates with the Senate or moderates his selections absent consultation, then his nominee may enjoy my support, as did Justices Kennedy and Souter." Now, Merrick Garland was a moderate selection. Indeed, in 2016, 5 days before President Obama nominated Chief Judge Garland, Senator Hatch was interviewed about the vacancy. Here's what he said, quote, "The president told me several times he's going to name a moderate to fill the vacancy, but I don't believe him. Obama could easily name Merrick Garland, who is a fine man. He probably won't do that because this appointment is about the election. So I'm pretty sure he'll name someone the Democratic base wants, unquote. But as it turns out, in recognition of the forthcoming election and the Republican Senate, President Obama did name a moderate. Now, part of what made Merrick Garland a moderate pick was the fact that he had a reputation for working with his colleagues on the D.C. Circuit to identify areas of agreement. Senator Klobuchar mentioned this. And to craft strong consensus decisions. When I met with Chief Judge Garland, I asked him how he does that. He told me that part of how he reaches consensus is by deciding a case on the narrowest grounds possible. By contrast, President Trump's nominee, Judge Gorsuch, doesn't seem quite as interested in reaching consensus or deciding cases narrowly. Also, Senator Klobuchar talked about this. Even when Judge Gorsuch agrees with majority in a case and joins their decision, he frequently writes his own concurring opinion, setting out his own views. Judge Gorsuch has done this 31 times, including writing 2 concurring opinions to majority decisions that he himself wrote. That's not seeking out consensus. That's holding his nose to join a consensus opinion and then writing separately to make clear that the decision would have been different if he could have persuaded his colleagues to see things his way, or perhaps to point the way to broader, more sweeping rulings in future cases. That kind of thinking gives me concern, particularly in light of what President Trump and his staff have been saying about Judge Gorsuch. White House Chief of Staff Reince Priebus, along with Chief Strategist Stephen Bannon, interviewed Judge Gorsuch before he was nominated by President Trump. They later appeared before right-wing activists at CPAC and told the crowd that a Justice Gorsuch would bring about, quote, a change of potentially 40 years of law, unquote. So that's what this is about. This isn't about finding a consensus nominee who only calls balls and strikes, a nominee like Merrick Garland. This is about confirming a nominee who will guarantee 40 years, 40 more years of 5-4 decisions favoring corporations over workers and consumers, of preventing Americans from getting access to the courts, of favoring big dark money in our election, and of giving states a permission slip to target certain people, quote, with almost surgical precision, unquote, in order to make it as difficult as possible for them to vote. Now, Judge Gorsuch took great pains to paint himself as a mainstream nominee. He said that the 10th Circuit ruled unanimously 97% of the time, that he was in the majority 99% of the time. That's about right. It was actually a little less, but doesn't matter. But that's not unusual. It doesn't really provide any insight into his approach of being a judge. After all, courts of appeals are required to follow Supreme Court precedent, and the vast majority of the cases all over the country in courts of appeals are decided unanimously. So while some of our colleagues on the other side accuse Democrats of cherry picking when we talked about certain cases where Judge Gorsuch wrote separate concurring opinions or where he dissented, those writings offer the clearest window into his judicial philosophy. Those are the cases that show us how Judge Gorsuch really thinks, and I'm afraid that these cases only underscore a disturbing pattern of siding with corporate interests against everyday Americans. I was particularly struck by Judge Gorsuch's dissent in Trans Am trucking. because in that case he seemed to bend himself into a pretzel in order to side with a trucking company against a truck driver. Now, you've all heard the story. Senator Feinstein described it again today, and what the situation the driver was in. But I just want to review the two choices that the truck driver was given by the trucking company, presented by his boss, after he had waited 3 hours in 14 below temperature in a cab that had no heat. He had fallen asleep at one point, only to be woken by a phone call from his cousin, thank God. His cousin reported later that he sounded woozy, and he wasn't tracking, that his torso hurt, he couldn't feel his feet, he had trouble breathing. All of these are signs of hypothermia, according to the Mayo Clinic. His boss, after 3 hours, gives him two choices. He can wait there with the trailer and his cab. The trailer has his load, and its brakes are frozen, literally frozen. He can wait there, maybe freeze to death, or he can go on the interstate at 2 in the morning with frozen brakes. The fastest you can go then is maybe 15 miles per hour. This is 2 in the morning, it's dark, it's icy. People are traveling on an interstate 80, 85 miles an hour this time of night. You go 85 miles up a hill, you come over the hill, and suddenly you're coming down on a semi that's going 10, 15 miles an hour. That's like going 70 miles an hour into a semi that is stopped. That's his second option. Instead, Madden does what any of us here would do. He unhitched the cab and drove it down the road to get warm. And after he warmed up, he came back. But he was fired. He was fired for abandoning his cargo. Now, there's a law to protect people in Madden's situation, so he files a case. When it gets to the 10th Circuit, a 3-judge panel agrees with Madden, the driver. They find that the trucking company shouldn't have fired him, but one judge dissented, Judge Neil Gorsuch. Here's what I want to get to. In the hearing, I asked Judge Gorsuch what he would have done if he were driving that truck. Which would you have chosen? I said. Which would you have done? And this is how Judge Gorsuch responded. Oh, Senator, I don't know what I would have done if I were in his shoes. Now, is there anyone here who had not done exactly what the driver did? I don't think so. Of course, you would unhitch the trailer and go find a place to get warm. Of course, of course. But Judge Gorsuch said he didn't know what he would have done. Is that possible? I asked him if he had even given any thought to what he would have done, and he didn't answer that. So I asked him again. Given the choice of sitting there and possibly freezing to death or going on the road with an unsafe vehicle or doing what Mr. Madden did, what would you have done? Judge Gorsuch responded, Senator, I don't know. I wasn't in the man's shoes. Judge Gorsuch says he decides cases based on the facts and the law alone. I go to the law, he said over and over again. But so, in fact, in this case, did the majority. Here's the operable law. Quote, a person may not discharge an employee who refuses to operate a vehicle because the employee has reasonable apprehension of serious injury to the employee or the public because of the vehicle's hazardous safety or security condition, unquote. The majority ruled that the company couldn't fire the truck driver because he had refused to operate the rig, the entire vehicle, because it was unsafe. But Judge Gorsuch said no, by operating the cab, he was operating the vehicle. Therefore, he didn't, quote, refuse to operate a vehicle. So he ruled against the driver. Judge Gorsuch said that he made the decision by applying the plain meaning rule. I pointed out that the plain meaning rule has an exception. Quote, when using the plain meaning rule would create an absurd result, court should depart from the plain meaning. Unquote. It's absurd to say that this company was in its rights to fire him because he refused to choose between possibly dying by freezing to death or possibly killing other people by driving a semi on an interstate at 10 miles an hour at 2 in the morning. The company is fortunate that Mr. Madden made the choice that he made, because otherwise they may very well have faced a wrongful death claim, which they probably would have tried to arbitrate. Now, everyone knows what Judge Gorsuch would have done in Alphonse Madden's situation. Everyone here in this room knows if Judge Gorsuch would have given an honest answer, he would have said that he would have done exactly what the driver did.
Can I read it?
Judge Gorsuch just didn't want to admit it. That's because there was no good answer to the question in the hearing. If Judge Gorsuch had said that he'd do the very same thing as Mr. Madden had done, that would make his dissent look every bit as absurd as it was. But if he had said, I would have done what the company told me to do, that would have told us that he has really bad judgment. Of course, he knew what he would have done. I defy any of my colleagues to come to me after this and say to me, he didn't know what he would have done. He just wasn't being honest. He wasn't being honest.
Well, thank you.
Frankly, there were a lot of questions Judge Gorsuch didn't answer in response to questions about precedent, about his judicial philosophy, and even about bedrock constitutional principles. Judge Gorsuch dodged, deflected, and obfuscated. His responses to Democratic members of this committee were cagey and evasive. Mr. Chairman, some of our questions may have been tough, but they were all fair. Judge Gorsuch has been nominated for a lifetime appointment to the highest court in the land. So my Democratic colleagues and I take seriously our responsibility to thoroughly examine his views. That's our job. That's what our constituents expect of us. And that's the point of a hearing. And I'm disappointed that Judge Gorsuch wasn't forthcoming with his answers. In the absence of answers, we have to rely on his record, and his record is not reassuring. During his time on the 10th Circuit, Judge Gorsuch has consistently ruled in favor of powerful interests. He sided with corporations over workers, corporations over consumers, and corporations over women's health. If confirmed, Judge Gorsuch would guarantee more of the same from the Roberts Court, a court that is already inclined to side with big business more than any Supreme Court since World War II. I don't believe that's a court that our country can afford. So in light of Judge Gorsuch's record, and in the absence of sufficient answers and honest answers to questions that were posed during the hearing, I oppose his nomination. And I urge my colleagues to think about that. To think about a judge when asked a straightforward question, in my judgment, did not answer truthfully. Thank you, Mr. Chairman.
Senator Flake.
Thank you, Mr. Chairman, and thank you for the way you conducted this whole process. You know, in 1987, I was here in the Senate as an intern in the office of a Democratic senator. My wife at the time was here as an employee of a Republican senator. She answered the phones. It was during the time of the Robert Bork hearings. I remember at that time being in awe of this august body, and this Judiciary Committee, and watching this committee deliberate. Judge Bork was extremely controversial. He ultimately was voted down on the Senate floor, but he wasn't filibustered. In 1991, we were still here, living in Washington at that time, my wife and myself. We watched the Clarence Thomas hearings. Extremely controversial, probably the most controversial nominee of our time. He received an affirmative vote on the Senate floor, very close, but he wasn't filibustered. One senator during either of those two nominations, just one senator could have filibustered, could have demanded a cloture vote. Not one senator did, because it simply wasn't the practice. In 2003, I was in the House of Representatives watching the Senate and watching with a lot of admiration those who formed the Gang of 14 to try to avert what we're seeing today. I remember thinking, where have we come? Why are we here? Why can't we adhere to the practice there's always been, that you give the president's executive calendar deference, you allow people to come to the floor for a vote. Later this week, we'll likely be forced with the prospect of changing the rules. And I think we shouldn't be here. I've not voted on a Supreme Court nominee. I have voted on controversial cabinet nominees. Just in the last couple of years, Loretta Lynch was put forward to replace Eric Holder. I can tell you it wasn't popular with my base, and it still isn't. I hear about it just about every day. And I voted to confirm her. I didn't agree with her philosophy. As Lindsey has said about other Supreme Court nominees, she behaved in terms of philosophy about exactly as I suspected that she would. She was true to what the president who nominated her expected of her. But I thought that she was qualified. And absent extraordinary circumstances, the president ought to get his or her nominees. At least they ought to get a floor vote. So I wish, Mr. Chairman, that we would instead
change the behavior of senators rather than change the rules of the Senate. But I think we are where we are, and I hope that in the future, when future nominees come up, I hope that if I'm in your position, in the minority, that I'll vote to advance, at least for a floor vote, the president's nominees, and I'll commit to do so if the person is qualified. And I think under any stretch to say that this good man before us, Judge Gorsuch, is not qualified for the position. Some may quibble about decisions or dissents that he's made. I would argue in the case that has been raised so much that it demonstrates precisely what Edmund Burke described as the cold neutrality of an impartial judge. He himself said that if a judge goes home at night and agrees with every decision that he's made, he's probably not a good judge. Because if his only client is the law, he'll likely not agree, not feel good about decisions that have been made. But I think that he's a good man, he's lived a good life, he's certainly qualified. And I hope that we can advance him for an up or down vote on the Senate floor. I yield back.
Senator Coons.
Thank you, Senator Graham. I'd like to thank all of my colleagues for the thorough and respectful and constructive way in which these hearings have been conducted. There have been just 112 Supreme Court justices in our nation's entire history, and these jurists have decided cases that have shaped the interpretation and application of our Constitution and influenced the lives of generations of Americans. Some of these cases are celebrated turning points in our nation's long quest to form a more perfect union. Cases like Brown versus Board of Education that ended racial segregation in schools. Cases like Gideon versus Wainwright that ensured that all, even criminal defendants, even the penniless, all are entitled to counsel. Cases like Obergefell that decided that it is the law of our land that loving couples can affirm their commitment in marriage, whether they are of opposite sex or same sex. There are other signature cases like Dred Scott, Plessy, or Korematsu that have left stains on our history that outlasted the service of any one justice. Since Justice Antonin Scalia passed away in February of 2016, I have reflected on the importance of our Supreme Court and the Senate's responsibility to evaluate the President's nominee to fulfill the vacancy. Just over 25 years ago, I was myself a law student intern on the Senate Judiciary Committee nomination unit for then-Chairman Joe Biden. And at that time, I heard from then long-serving senators a record of grievances, of misunderstandings, of wrongs committed one party against the other in a variety of confirmations and hearings in the Bush and Reagan administrations and before. And I'm struck that half of the committee serving here today hasn't previously participated in any Supreme Court confirmation on this committee. When Justice Scalia died, I called on President Obama to nominate a consensus candidate to the court that would help us to bridge our deep partisan divides and enhance the legitimacy of the court on which our rule of law so profoundly depends. And President Obama did just that. He nominated Chief Judge Merrick Garland, by any accounts, one of the most centrist and confirmable nominees ever nominated to the Supreme Court. But instead of healing the wounds left by partisan battles long since past, new ones formed. Republicans held the seat open for over 300 days without regard for the damage of doing so to the court or to this body. And I appreciate my colleague Senator Franken's defense of the speech once given by my former boss on this committee, Senator Biden. Let me be clear, this action by my colleagues was unacceptable and has scarred this process and this body. As Senator Cornyn previously remarked, there has never been a partisan filibuster of a Supreme Court nominee in history. And while technically correct, I question what a 7-month refusal to hold a hearing or vote is, if not the longest partisan filibuster on this committee ever. I haven't forgotten the injustice done to Judge Merrick Garland, and neither have any of my colleagues. But we simply cannot move this committee and this body forward if we simply endlessly obsess over past grievances and revenge. And so, unlike the majority leader who announced before there was any nominee from President Obama that he would get no hearing. I pledged to treat President Trump's nominee, Judge Neil Gorsuch, fairly and to engage actively in this process, and I did so. And throughout this process, I have kept an open mind. After reviewing Judge Gorsuch's record, after meeting with him twice, after participating in 4 days of very well-run Senate Judiciary Committee confirmation hearings, submitting written questions, and getting feedback from literally thousands of Delawareans, I have decided that I will not support Judge Gorsuch's nomination in the Judiciary Committee today. I appreciate that Judge Gorsuch is an intelligent jurist, an engaging writer. I admire his commitment to being a good father to his daughters and a good husband to his wife and a good mentor to his clerks, and I even agree with many of his decisions. But I believe that my role in evaluating his nomination is more than reviewing his resume. It is more than recognizing he is smart and charming, and I have to do more than think about a large number of consensus decisions, because the law is shaped by circuit courts, and even more so the Supreme Court, by a handful of very significant signature decisions. And thus, I must follow my predecessor's practice in considering Judge Gorsuch's philosophy and its impact on the constitutional rights of others, even those very different from himself and with values different from his own. That's why my questions at Judge Gorsuch's hearings focused on his view of Americans' rights to privacy and liberty to make their most important personal life decisions. At the hearings, I focused in on a 10th Circuit case written by Judge Gorsuch, Hobby Lobby, which for the first time allowed for-profit companies to refuse to provide thousands of employees access to family planning based on the for-profit corporation's religious beliefs. I laid out in great detail in the confirmation hearing questioning why I viewed that as not just a strained reading or an overreach, but as one that is wildly outside the context of the Dictionary Act and of previous law. But I think I can summarize this best by quoting Chief Judge Briscoe's dissent in that same case. It struck me. She said that Judge Gorsuch's view was, quote, nothing short of a radical revision of First Amendment law, as well as the law of corporations, and that such views were wholly unsupported by the language of the Free Exercise Clause or the Supreme Court's free exercise jurisprudence, close quote. In his concurrence in Hobby Lobby, Judge Gorsuch advanced a broad theory of the Religious Freedom Restoration Act under which an employer could avoid complying with any neutral, universally applicable law in order to avoid complicity in the wrongdoing of others. And I pressed Judge Gorsuch to give me a limiting principle to this new complicity theory, but was left in the end with more questions than answers. I also asked Judge Gorsuch about his understanding of core constitutional provisions that protect reproductive rights, death with dignity, and marriage equality. In his 2006 book, The Future of Assisted Suicide and Euthanasia, Judge Gorsuch was critical of individuals' rights to make their own end-of-life decisions and asserted, and I quote, that all human beings are intrinsically valuable and the intentional taking of life by private persons is always wrong. His book and other comments suggest a very narrow interpretation of a key precedent, Planned Parenthood of Southeastern Pennsylvania versus Casey, an absolutely central case to addressing personal liberty and reproductive rights as protected under the 14th Amendment's Due Process Clause. Casey is a critical precedent that the Supreme Court has continually relied on for 25 years to protect the freedom of many, including most recently the freedom of same-sex couples to have intimate relationships and to support marriage equality as the law of the land. On each of these important issues and more, Judge Gorsuch avoided responding concisely and thoroughly to questions. In fact, as detailed by Senator Feinstein, he avoided responding to questions that many other nominees, nominated by both Republicans and Democrats, have not just answered, but answered squarely. He told me that the Casey decision remains an open question in many ways. He would not agree with me that the right to privacy today extends to protecting women's rights to have autonomy over the reproductive choices and protecting the privacy of intimate relations between consenting adults, whether same-sex or of the opposite sex. This and many more left me concerned Judge Gorsuch harbors a restrictive view of the right to privacy and personal liberty rooted in the Due Process Clause of the 14th Amendment. Let me be clear, I don't think these and other issues raised by many of my colleagues are just narrowly partisan issues. And I think it is unfortunate if we lead the public to view members of the Supreme Court simply as red pegs or blue pegs deciding cases along partisan lines. Because there are many, many cases that are decided not along partisan lines, but along lines that are narrowly legal. In fact, I think in 60% of the cases decided by the court, they are unanimous. Indeed, several justices nominated by Republican presidents have appreciated exactly this point, the important role of 14th Amendment due process in securing our individual liberties, and have taken a far more restrained view of their judicial role than Judge Gorsuch's record suggests he would adopt. Judge Gorsuch's record shows a tendency to searchingly explore broader issues than what is necessary to decide the case before him, a willingness to revisit long-settled precedent and to promote actively changes to the law. As others have discussed, he has insisted the Chevron doctrine should be revisited. This doctrine is a long-standing precedent that ensures judicial deference to agency experts responsible for health and safety, environmental and consumer protection regulations. And for me, even more troubling, he suggested restricting access to federal court for actions brought under Section 1983, a critical tool for civil rights enforcement. It is based on these and many other concerns that I've detailed in my questioning, my questions for the record, and in further statements I've made, that I will ultimately vote against Judge Gorsuch's nomination today. Still, I share the view of many of my colleagues that Judge Gorsuch is a talented, experienced jurist. I understand why all of my Republican colleagues will support him and why some of my Democratic colleagues will support him today as well. I cast my vote well aware that he will receive the required votes on this committee to advance to the full Senate. We are at an historic moment in the history of the United States Senate. Thanks to actions, decisions, even mistakes made by both Democrats and Republicans over recent years, over many years, we have eroded the process for reaching agreement and dishonored our long traditions of acting above partisanship, especially when it comes to confirmations for judges and now justices. I said last week it would be tragic if Judge Gorsuch's confirmation process leads the Senate Republicans to join the majority leader in abolishing the 60-vote threshold for cloture on the nomination of a Supreme Court justice. Let's be frank, the majority leader has assured us he will abolish the 60-vote threshold for Judge Gorsuch if 8 Democrats don't support him on the Senate floor. I don't agree with that approach, but like it or not, as a number of you have asserted today, that is the reality. On Thursday, the full Senate will participate in what's called a cloture vote. It's one of the Senate's many long traditions, and though many Americans may not know exactly what it means that we are done debating, that we are ready for the final vote. And almost always a combination of both Democrats and Republicans are required for us to get to cloture. So on Thursday, we'll be voting to decide whether we are ready to finish debating the confirmation of Judge Gorsuch. I am not ready to end debate on this issue, so I will be voting against cloture unless we are able, as a body, to finally sit down and find a way to avoid the nuclear option and ensure the process to fill the next vacancy on the court is not a narrowly partisan process, but rather an opportunity of both parties to weigh in and ensure we place a judge on the court who can secure support from members of both parties. The reality we are in requires us over the next several days to consider what both Democrats and Republicans are doing to this body, and to consider what both Republicans and Democrats have done to erode the trust that has long lasted between us, and to consider whether we can stop the undeniable momentum towards abolishing the traditions that make this Senate unique and important. Democrats, including me, are still furious at the way Judge Merrick Garland was treated last year. But the traditions and principles that have defined the Senate are crumbling, and we are poised to hasten that destruction this week. So for my part, I hope and pray that we can yet find a way together to find a solution. Thank you, Mr. Chairman.
Thank you. Senator Crapo.
Thank you very much, Mr. Chairman. Judge Gorsuch has shown himself to be a judge of unwavering commitment to our laws and to upholding the separation of powers defined in our Constitution. The American Bar Association prides itself on serving as a neutral arbiter of the standards of the legal profession in this country, And as we have all heard today, the ABA has bestowed on Judge Gorsuch its highest possible evaluation. Their report is full of excerpts such as the following. Judge Gorsuch enjoys an excellent reputation for integrity and is a person of outstanding character. I have known and interacted professionally with Judge Gorsuch since his appointment to the 10th Circuit Court of Appeals. In my experience as a judge, I cannot identify a person more qualified in every sense of the word to serve as an Associate Justice of the United States Supreme Court. And Judge Gorsuch believes strongly in the independence of the judicial branch of government, and we predict that he will be a strong but respectful voice in protecting it. The Judiciary Committee recently concluded a 4-day review of this nomination, in addition to hearing from Judge Gorsuch for over 20 hours. The committee received formal testimony from almost 30 outside witnesses. Thousands upon thousands of words were exchanged over the course of the hearing, all in front of the American people. What the people saw is a thoughtful, humble, and brilliant legal mind in the service of the public. In response to a question of mine on Tuesday, Judge Gorsuch said the following: I come here with no agenda but one, no promises but one, to be as good and faithful a judge as I know how to be. That is it, and I cannot promise or agree or pledge anything more than that to this Congress. That statement and the hearing as a whole confirmed Judge Gorsuch to be a man of great integrity, of the mainstream, an exemplary student of the law whose record shows that he is part of unanimous decisions 97% of the time and 99% of the time in the majority. For days, a number of my colleagues from the other side of the aisle have raised the possibility that he might have secret intentions to subvert the rule of law or to shred the Constitution from the bench. They've parsed single words for hidden meanings, imagined devious strategies emerging from concurring opinions, and searched for cloaked messages in his published writings. Judge Gorsuch has over 10 years as a jurist with 2,700 opinions to review, yet most of the debate was focused on just 4 or 5 cases. Let's talk about what Judge Gorsuch testified to under oath. In the face of repeated insistence that he take a position on how some case should be ruled, should have been handled, or should be handled in the future, he kept focusing on following precedent and following the law. On his first day, he gave no fewer than 8 assurances that he follows the law as a judge. By my count, on the second day, he gave at least 36 assurances that he looks to the law for his rulings. And on the third day, it was 29 more times. That's right. By my count, at least, he said 73 times in the hearing that he's committed to the law when he hears a case sitting as a federal judge. Still, many worried that he had a secret agenda to overturn long-standing legal precedents. Just in case some are confused, Judge Gorsuch mentioned no fewer than 97 times that he follows precedent as a judge, as he is bound to do. More than 160 times, Judge Gorsuch reminded the Senate and the American public what a proper jurist does: follow the law and the precedent. We even talked about the book he co-sponsored or co-wrote, The Law of Judicial Precedent, 942 pages of dedication to following precedent. During his oral testimony, he dedicated to, and these are his words, ruling as the law requires, reading the language of the statute as a reasonable person would understand it, and respecting precedent. And just to put all these questions to rest, he assured everyone that he is without secret agenda, none. In reviewing his record, it's clear to me that those who come before Judge Gorsuch receive equal treatment under the law. He said in his hearing, when I sit on the bench and someone comes to argue before me, I treat each one of them equally. They do not come as rich or poor, big guy or little guy. They come as a person, and I put my ego aside when I put on that robe, and I open my mind, and I open my heart, and I listen. I asked him, as some had intimated, whether when he was nominated he was required by the president to make some commitment to the president as to how he would rule on some case or how he would resolve some issue. In fact, I expanded my question, if I call correctly, to whether the president or anyone at the White House or in the administration had made such a demand of him. His response to me was that he had not been asked to do so, and had he been asked, he would have walked out of the room. Judge Gorsuch will follow the law and follow precedent, as his career has shown. Let me turn quickly to just a couple of the issues that have been raised. Some have raised the issue of what they call dark money today, saying that there are some people and organizations who are so hopeful that he gets nominated and confirmed that they are actually spending money to support his nomination. That's true. What the opponents don't say is that there are other people and other organizations who are so opposed to his nomination that they are spending millions of dollars in opposition to his nomination. That's also true. And as our chairman said in his opening remarks, that's part of our system in America. And for those who are today claiming that because some support his nomination, that he must therefore be committed to their agenda, is simply false. Judge Gorsuch has shown himself to be a man of character and integrity who will follow the law and honor precedent. And let me clear up the Brown versus Board of Education attacks. There's been attacks then in the hearing and attacks here today saying that he won't say whether he supports the ruling and understands the issues in Brown versus Board of Education. Well, let me read his exact testimony to this committee in his hearing. On day 2, he stated, Brown versus Board of Education corrected an erroneous decision, a badly erroneous decision, and vindicated a dissent by the first Justice Harlan in Plessy versus Ferguson, where he correctly identified that separate to advantage one race can never be equal. He went on to say on that same day, Justice Harlan got the original meaning of the Equal Protection Clause right the first time, and the court recognized that belatedly. It is one of the great stains on the Supreme Court's history that it took it so long to get to that decision. On the third day, when the issue was raised again, as if that was not clear enough, he stated, it is a seminal, Brown versus Board of Education, is a seminal decision of the United States Supreme Court interpreting the 14th Amendment, maybe one of the great moments in the Supreme Court history. Again, he said, I've said it was a seminal question of the United States Supreme Court that corrected a badly erroneous decision and vindicated the original understanding and the correct original understanding of the 14th Amendment, and is one of the shining moments of constitutional history of the United States Supreme Court. That is what I've said. And then after it went on, he finally said, we are all on the same page on Brown versus Board of Education, Senator. Notwithstanding all of the incredible support and the clear evidence that Judge Gorsuch is qualified, there are still those of my colleagues who are advocating for the extreme step of filibustering Judge Gorsuch's nomination. Many today have given reasons why they personally are going to vote no. But voting no is different from filibustering. The argument is being made that all Supreme Court justices are submitted to a 60-vote rule, not a 50+1 rule. That's simply not true. The opponents can attempt to indefinitely delay his confirmation, but they cannot defend this as regular or established practice. None of the current sitting justices were subjected to a filibuster. None. 2 were even confirmed with fewer than 60 votes, but neither were subjected to that procedural roadblock. When President Obama nominated Justices Sotomayor and Kagan, Republicans did not subject them to a filibuster. They received a straight up or down vote. The same was true when President Clinton selected Justices Ginsburg and Breyer. Republicans did not seek or demand a filibuster. Even Judge Bork did not face a filibuster. all senators had an opportunity to vote on his nomination. And although throughout history there have been a few, and I mean a few, examples of where filibusters were tried, a partisan filibuster has never succeeded in the Senate. Just a little bit of history. There wasn't even a cloture process on judges until 1949. Prior to that time, cloture was not an issue. Since 1949, there have been four, exactly and only four, cases in which cloture was sought, where a filibuster was sought to be sustained relating to a Supreme Court nomination. The first came in 1968 with the case of Abe Fortas when he was being nominated to be the Chief Justice of the court. That is not only the first, but the only case in which a filibuster was maintained. And it was maintained because it was bipartisan. In that instance, Justice Fortas, then under a serious ethical cloud, faced 19 Democrats who voted to block his nomination, almost as many as the 24 Republicans who also voted to block the nomination. That's a slender thread to hang arguments in favor of blocking Judge Gorsuch from the Supreme Court. Even Judge Gorsuch's harshest critics have never suggested a whisper of misconduct by him. The other three cases, by the way, were Justice Rehnquist in 1971, when the full Senate rejected the filibuster, Justice Rehnquist again when he was nominated as Chief Justice in 1986, when the full Senate rejected the filibuster, and Justice Alito in 2006, when 72 senators rejected the effort to try to filibuster a Supreme Court nomination. The argument that justices nominated to the Supreme Court are subjected to a 60-vote rule is simply false. I understand that some are disappointed by the outcome of the November election, but it's quite a stretch to try to make the argument that the Senate requires 60 votes on a Supreme Court nomination. In fact, this argument was reviewed by the Washington Post, which gave it 3 Pinocchios, calling this a false talking point taken to an absurd extreme and using verbal gymnastics to obscure the truth. This claim only received 3 Pinocchios is an undeserved kindness from the Washington Post. In Judge Gorsuch, we have a nominee who lives the American ideal of a modest jurist. He understands that his responsibility is not to suborn the powers of others, but to help deliver justice. Those who have encountered him as a legal advocate, as an adversary in court, or a presiding judge all praise his fundamental fairness and suborning of his personal views.
Was I watching?
His respect for the Constitution is not in question. His experience, his wisdom, and judgment are not in question. His capability to serve is not in question. Commentators from both the left and the right overwhelmingly respect his legal mind and vouch for his commitment to fair jurisprudence. Given Judge Gorsuch's judicial philosophy and his record as a judge, he would be a welcome addition to the Supreme Court, seeking cohesive decisions. His record on the 10th Circuit is strong. 5 of 6 of his decisions have been affirmed by the Supreme Court, including one which he wrote and 4 out of 5 on which he joined. Not many judges have the experience, temperament, and stellar record to match Judge Gorsuch. Fewer still can garner overwhelming endorsement from colleagues, peers, and observers from across the political spectrum. Some may try to distract from the central point that Judge Gorsuch is extraordinarily qualified and suited to serve as an associate justice. Others would like to discuss other things or make this nomination a proxy fight about other tangential matters. But my colleagues and I will vote on his nomination, not those distractions. And I encourage all of us to remember that. The Senate should be proud to add Judge Gorsuch to the Supreme Court. Thank you, Mr. Chairman.
Before I call on Senator Blumenthal, we have 3 on our side and 2 on the Democrat side. And if they speak about the average of everybody else, we should be getting to a vote soon after 2 o'clock. So I just thought I would tell everybody how I think it's going to work out so everybody can be here to cast their vote. Senator Blumenthal.
Thanks, Mr. Chairman. I want to join in thanking you and our ranking member for conducting this hearing in such a fair and enlightening way, and thank my colleagues also for remarks that I have found very helpful. You said at the outset, Mr. Chairman, that there was no mystery about how the outcome would be today, and perhaps regrettably that is so. But there is a mystery about the Supreme Court. It's an institution that functions in complete secrecy. It is anachronistic in a democratic government, in fact, the greatest democracy in the history of the world. It's unaccountable, unelected, 9 men and women having power for life in the highest court of the land to strike down actions by this body and by the executive branch elected by the people. It has no armies or police force. Its power derives from credibility and trust. It is a mystery in a democracy, and yet it protects individual rights and liberties as no other institution can. And it does so because people have faith in its integrity, that it is above politics. That's why I believe strongly that approval of Supreme Court justices must be by more than a razor-thin majority. Approval should be done with a bipartisan consensus, as has been the case almost uniformly throughout our history. Presidents have consulted with both sides of the aisle before they made a nomination, and we still have a path forward
Don't you guys have a plan?
in seeking a consensus nominee. I will vote against the nomination of Judge Neil Gorsuch today. I made this decision after questioning him extensively in private and in our hearing, reviewing his record, and deliberating carefully and deeply. It's one of the most important votes I will ever cast. I am still angry about the treatment of Merrick Garland.
I do too.
Our Republican colleagues have said that if the shoe were on the other foot, this side would have done the same. It would have been as wrong if we had done it as it was when they did. But my vote is not about Merrick Garland. It is all about Neil Gorsuch. And it is about the constitutional crisis that may well be looming as a potential threat to our democracy. The FBI director has revealed that his agency is investigating ties between President Donald Trump's associates and Russian meddling in our election. The independence of our judicial branch has never been more threatened or more important.
Merrick Garland.
The possibility of a Supreme Court needing to enforce a subpoena against the President of the United States is far from idle speculation. It has happened before in United States versus Nixon. President Trump has launched a campaign of vicious and relentless attacks on the credibility of our judiciary. His disparaging comments have attempted to shake the foundations of respect for judicial rulings, the credibility and trust that is so essential to our Supreme Court and all our courts. And it is a respect that is vital to holding the President himself accountable to the people and our Constitution. President Trump's disrespect for our judiciary was demonstrated by how he selected this nominee. He promised a litmus test, a nominee who would, in quotes, automatically overturn Roe v. Wade, strike down gun violence prevention measures, and be of a conservative bent. He outsourced the selection process to right-wing groups like the Heritage Foundation, choosing from their approved list. Against this backdrop, Judge Gorsuch had a special obligation to be forthcoming, not to prejudge the merits of a particular case, but to share his core beliefs on long-standing, well-established precedents and demonstrate his commitment to the independence of our judiciary. Instead, he has evaded real answers at every turn. We have to assume that Judge Gorsuch has passed the Trump litmus test, pro-life, pro-gun, conservative. In question after question, I gave Judge Gorsuch, as did my colleagues, an opportunity to distance himself from those right-wing groups. His refusal to answer those questions only deepens the doubt that he is not a neutral follower of the law or an umpire who just calls balls and strikes, but instead an acolyte of hard right special interests. In fact, as recently as late last week, he doubled down on evading those questions about specific cases in the written responses that he submitted to me. I wanted to give him every benefit of the doubt and give him every opportunity to say, as a number of his predecessors had done, including Justices Alito and Kennedy and Chief Justice Roberts, that core precedents were rightly decided and correct. And we are talking not only about Brown versus Board of Education, but Griswold versus Connecticut, the right of married couples to use contraceptives in their own home. Loving versus Virginia, the right of couples of different races to marry. Obergefell versus Hodges, the right of same-sex couples to marry the person they love. And other key cases involving equal treatment under the rule of law and the right of privacy, which is central not only to the reproductive rights of women and men, but also rights against illegal surveillance by the government and snooping and spying on private lives. These issues are not hot-button controversies. They are core cases that stand for principles like the rights to privacy and equal treatment. But Judge Gorsuch dodged all of them. He summarized the cases. He told us how old the opinions are. He reminded us they're Supreme Court opinions, but he provided no affirmation that he agrees with these decisions or their constitutional tenets. A justice who fails to share these basic values and believe that these decisions are correct, in my view, is outside the mainstream and a potential threat to constitutional rights that protect the lives and livelihoods of millions of Americans. For most Americans, the Chevron doctrine is virtually unknown and perhaps would be incomprehensible, but it underlies a great deal of the faith and respect that is given to the work of agencies responsible for protecting consumers and workers and others who exercise their rights. I'm going to quote from an article of just the past few days that I asked, Mr. Chairman, be entered into the record. It's "The Government Gorsuch Wants to Undo" by Emily Bazelon and Eric Posner.
So ordered. It'll be put in the record.
The reality, quote, "The reality is that Judge Gorsuch embraces a judicial philosophy that would do nothing less than undermine the structure of modern government, including the rules that keep our water clean, regulate the financial markets, and protect workers and consumers." That kind of approach to enforcement undermines respect for law and the rule of law. The Supreme Court is more than marble pillars and judicial robes. It's the embodiment of American justice. It is the flesh and blood embodiment of American justice. justice that has a human face and voice. Its decisions must ensure that the rule of law is preserved for real people and that our Constitution continues to protect us from overreach and tyranny. And that's why it's so important that the nominee to the Supreme Court be approved by more than 60 votes, not that razor-thin majority that we are heading toward today. And that's why I will use and support the filibuster, if necessary, to oppose his nomination. Judge Gorsuch did say that he would follow the law. But as I said to him in my last round of questioning, Supreme Court justices are not automatons. There's no algorithm that enables them to simply follow the law. In fact, they resolve issues where the laws conflict, where constitutional rights bump against each other, and where circuits of the courts of appeals conflict. So core beliefs matter, and adherence to precedent, and acknowledgement that certain decisions are correctly decided all matter. And today we still know very little about Judge Gorsuch's core beliefs. But here is what we do know. We know that the man who hired him has said he passes his right-wing litmus test. We know that right-wing conservative organizations have spent millions of dollars on the prospect that he will move American law dramatically to the right. And we know that he will not answer questions that his predecessors, like Justices Alito and Kennedy and Chief Justice Roberts, were willing to answer about core tenets of American jurisprudence. In short, he has left us with substantial doubt. That doubt leaves women wondering how long they will have autonomy over their health care decisions. Same-sex couples questioning whether they might be denied the right to marry the person they love, workers and consumers doubting their rights, and Americans fearing the court will abandon protections of privacy and equal protection under the rule of law. That doubt is why I cannot support this nomination and why I will join in a filibuster, if there is one, to stop it. Mr. Chairman, I'd like to just state briefly as well my position on the nominee for Deputy Attorney General Rod Rosenstein. I agree with my colleagues that he is a nominee with a very impressive background and qualifications, and I would vote for him if he agreed to appoint a special prosecutor to investigate the Russian interference in our past election, the potential involvement or collusive action involving Trump associates in that meddling, and other matters related to that set of incidences. I believe a special prosecutor is absolutely necessary to do the investigation and to hold accountable anyone responsible for colluding with the Russians. The facts have been established that the Russians sought to affect the outcome. Whether they did or not is immaterial. But through a concerted campaign of cyber attack amounting to an act of war on this country, misinformation, propaganda, they sought to affect the outcome of that election. The intelligence committees of both houses may do an investigation. And there may be an independent commission, as I believe there should be, to make findings and recommendations and do a report that will be fully transparent, maybe more so than the intelligence committees. But only a special prosecutor can hold accountable criminal wrongdoers. No other body in Congress or elsewhere can prosecute and bring criminal charges. That's why I think a special prosecutor is necessary, with the independence and impartiality to investigate vigorously and thoroughly. The intelligence committees of the Senate hopefully will do their job. But even if they do, they cannot prosecute and hold accountable criminally the wrongdoers who may have been involved in that Russian interference in our election. The Attorney General has recused himself. The deputy, who is a nominee here, has the power now and responsibility to do it. I have asked him for a commitment that he will do it. So far, he has not given that commitment, and therefore I will vote against him today, and I will work against him as long as he declines to give that commitment. Thank you, Mr. Chairman.
Okay. Senator Cruz.
Thank you, Mr. Chairman, and let me commend the manner in which you have conducted this hearing with fairness, with an opportunity for both sides to ask their questions, to express their views, and to address all of the issues that are raised by a Supreme Court nomination. It speaks well that even in this highly contentious, highly partisan time, that our colleagues on the Democratic side of the aisle have consistently praised your leadership of this committee, and I certainly join in that praise.
Thank you.
Much of the criticism that the Democratic senators on this committee have raised about Judge Gorsuch has focused on a handful of cases and particular litigants who are sympathetic litigants, and focusing on which litigant prevailed. And I want to take a moment to discuss the relationship of process to results. Conservatives and liberals have a different view about the process by which courts should arrive upon their decisions. Conservatives understand that it is the role of a judge, and especially the role of a Supreme Court justice, simply to follow the law, to apply the Constitution, to apply the Bill of Rights, to apply statutes passed by Congress and signed into law by the President. Liberals, on the other hand, by and large, view the process as achieving the result that they want, view the process of adjudicating a case as a political process. Now, there is a consequence of those two processes, because I will say there is an issue at stake here about which principle prevails, and it's a results issue. In many cases, you have a conflict between government and individual liberty. And for a liberal judge who is engaged in results-oriented judging, the outcome of that choice is almost always siding with government. It is a support of government power at the expense of individual liberty. On the other hand, for those who would follow the law and follow the Constitution, in a great many instances, individual liberty will and should prevail over government power. And the reason is simple. The Constitution has a bias towards liberty. If you are following the Constitution and Bill of Rights, you are following a document that was created to protect individual liberty. So, for example, on free speech, those on the left that want results-oriented liberals on the court view free speech often as an inconvenience, and given a choice between government power and an individual's right to speak in a political context, will consistently side with government power to muzzle the free speech of individual citizens. That is profoundly inconsistent, I believe, with the First Amendment to the Constitution. Likewise, the Second Amendment, the right to keep and bear arms. If you have a liberal, results-oriented judge who believes in restricting guns, believes in restricting individual liberty to keep and bear arms, then that outcome will be siding with government and the power to take away your right to defend yourself, to defend your family, to defend your home. On the other hand, the Constitution, if you're following the Bill of Rights, has a bias towards individual liberty. The Second Amendment explicitly protects the individual liberty to keep and bear arms, to protect your family, to protect your life and your loved ones. Likewise, when it comes to religious liberty, If a judge is a liberal, results-oriented judge, then religious liberty is seen as an inconvenience, a minor impediment standing in the way of unfettered government authority. On the other hand, if you have a judge committed to following the Constitution and the Bill of Rights, then the First Amendment's protection of religious liberty is fundamental and must be protected. You know, it is interesting, some of my Democratic friends have asked Judge Gorsuch if he would be willing to stand up to President Trump. I'll tell you, any constitutionalist who is following the law is by definition willing to stand up to a president of either party, including the president who appointed him, if that president or that administration exceeds constitutional authority. In my view, and I think the view of the senators on this side of the aisle, we are not confirming a political player. We are not confirming someone who will simply vote with our team on a given issue. And if this president or the next president or the next president contravenes the Constitution and Bill of Rights, contravenes the individual rights of citizens, then I have every hope and expectation that Judge Gorsuch and any other constitutionalist would without hesitation side with the law over government power. That connection between process and results is very real. And this nomination is unusual in the annals of history. It is unusual because the presidential election was in many ways a referendum on this nomination. The vacancy occurred last year in the midst of a presidential election season, in the midst of the primaries. And the Senate majority, quite rightly, I believe, concluded that we would not fill the vacancy in the middle of a presidential election. Rather, we would allow the people to decide what sort of justice would fill this seat. And President Trump did an unprecedented step. He laid out a list of 21 specific nominees, and he promised the American people he would nominate from that list. I am not aware of any president in history who has done the same thing, who has laid out for the American people, these are the specific individuals from which I will choose this nominee. Judge Gorsuch was one of those 21. The American people, in going to vote in November, knew specifically the individuals who would be considered, and they knew a very different vision that Hillary Clinton promised. Hillary Clinton promised to nominate liberal judicial activists who would undermine free speech, who would undermine the Second Amendment, who would undermine religious liberty. And in November of last year, the American people had a choice. This was a referendum on Justice Scalia's vacancy. And the result of this election, I believe, was an overwhelming mandate for a justice who will protect our individual liberties, who will follow the Constitution, who will follow the Bill of Rights, who will follow the law. Given that the American people had the opportunity to vote and choose which path the court should go, I believe that confers upon this nomination a kind of super legitimacy, where it is not just the president's nomination, but it is the president's nomination validated by the choice of the American people exercised at the ballot box. Now, given that, why is it that our friends on the Democratic side of the aisle are so unified in their opposition? In fact, unified to the point of promising an unprecedented filibuster of a Supreme Court justice. Well, the reason is not the merits. There is no credible argument that can be given that Judge Gorsuch is anything but impeccably qualified to serve on the Supreme Court. Columbia undergraduate, Harvard Law School, Oxford, clerking for Justice Byron White, who I note was appointed to the court by John F. Kennedy, serving a decade as a distinguished federal court of appeals judge. On the merits, Judge Gorsuch is indisputably qualified, and that's the reason why we've seen a litany of liberals testifying to Judge Gorsuch's merits. Neil Gorsuch, the former acting Solicitor General for President Obama, wrote that Judge Gorsuch was, quote, one of the most thoughtful and brilliant judges to have served our nation over the last century. Quote, as those of us who have worked with him can attest, he is a wonderfully decent and humane person. Those are the words of President Obama's former acting Solicitor General. Norm Eisen, President Obama's former ethics czar, was a classmate of Judge Gorsuch's at Harvard. Eisen joined a letter with 57 Harvard Law School classmates stating that, quote, we unanimously believe Neil possesses the exemplary character, outstanding intellect, steady temperament, humility, and open-mindedness to be an excellent addition to the United States Supreme Court. That is from President Obama's former ethics czar. David Frederick, a former law partner of Judge Gorsuch, a progressive Democrat, a board member of the American Constitution Society, the left-wing equivalent of the Federalist Society. What did he have to say? Quote, the Senate should confirm him because there is no principled reason to vote no. That's not a conservative saying that. That is a well-known liberal. Or for that matter, Judge Gorsuch's hometown newspaper, the Denver Post, which I might note endorsed Hillary Clinton in the presidential election. It is not a conservative newspaper, but here's what the Denver Post said. Quote, we hope the Senate manages to place him on the high court in short order. Gorsuch is a brilliant legal mind and talented writer whom observers praise for his ability to apply the law fairly and consistently. We appreciate his desire to strictly interpret the Constitution based on the intent of our nation's founders, even when those rulings might contradict his personal beliefs. On the merits, this decision would be easy indeed. If this were being decided on the merits, Judge Gorsuch would be confirmed 100-0. And we don't have to speculate about that because he has been. A decade ago on the Court of Appeals, the Senate confirmed him by voice vote, which means not a single Democrat spoke out against his confirmation. Not Senator Feinstein, not Senator Leahy, not then Senator Obama, not then Senator Hillary Clinton, not then Senator Joe Biden. So what's changed in a decade? We have a decade of exemplary service on the Court of Appeals that makes his nomination even stronger, but something else has changed, the politics of it. You know, it's interesting that a number of Democratic senators have talked about what they call dark money, organizations that are expressing free speech to share their views about Judge Gorsuch. There's an irony to the attack of my Democratic colleagues, because it is indeed because of dark money from corporations that we are seeing this Democratic filibuster. What explains the conduct here is simple. It is politics. And the politics are that in the Democratic Party, there are outside groups that are corporations, mind you, that are organized and formally incorporated, that are spending vast sums of money to organize left-wing activists to put political pressure on Senate Democrats. And it is that political pressure which is yielding the unprecedented result here. A Democratic senator some weeks ago told me, in a moment of candor, you got to understand, all of us on the Democratic side, we're afraid of being primaried from the left. We're afraid of doing anything other than opposing Trump on everything. That's what we're seeing playing out. It is the action of a handful of left-wing billionaires spending money to organize activists on the ground that are, in effect, holding Democratic senators hostage. Now, that may be a reality of politics, an unfortunate reality of politics and where we are, but it is not a sound and principled reason to reject a Supreme Court justice who is unquestionably qualified and whose nomination enjoys the imprimatur of the American people voting in an election and choosing the kind of justice that should replace Justice Scalia. This week, the Senate, I am convinced, will confirm Judge Gorsuch as the next Associate Justice on the Supreme Court. And when that happens, that will be a victory for individual liberty. It will be a victory for the Constitution and Bill of Rights, and it will be a victory for the people. Thank you, Mr. Chairman.
Thank you, Mr. Chairman, for the conduct of these hearings for Judge Gorsuch. I would have liked for the process to have been made available for Judge Merrick Garland as well.
Could you pull the microphone a little closer to you, please?
Speak up a little. Can you hear me now?
And Senator Feinstein said, speak up a little bit.
Okay, I'll get closer. I started off by saying that it would have been great if this process of 4 days of hearings for Judge Gorsuch could have been made available for Judge Merrick Garland as well. I think the irony is that it was not. And to hear my colleagues talk about how the Democratic senators or the Democrats are afraid of being primaried, please. That hardly even bears any kind of response from us. Over the past 2 months, Donald Trump has nominated a parade of extreme and unqualified people to important government positions. We have an education secretary who doesn't even believe in public education, a treasury secretary who profited from the 2008 mortgage crisis, Environmental Protection Agency administrator who seems to not believe in environmental protection. I could go on. So when Donald Trump nominated Neil Gorsuch to serve on the Supreme Court, you could almost hear an audible gasp of relief. President Trump didn't nominate a member of his family. He didn't nominate a television personality. He nominated a Columbia and Harvard-educated lawyer with 10 years of experience on the circuit court. But we cannot and should not evaluate Judge Gorsuch on the basis of, I have to say, the very low bar that President Trump has established for his nominees. Paper credentials are not enough. This is for the highest court of the land, a lifetime appointment, a court that makes decisions that impacts all of our lives. And should Judge Gorsuch get nominated, he will be on that court long before a lot of us are gone. And we should not give Judge Gorsuch a pass just because he has these credentials. Judge Gorsuch's nomination is a product of a year-long campaign by extreme right-wing organizations to continue to transform the Supreme Court in its image, in their image. During the campaign, President Trump had a clear litmus test for his Supreme Court nominee. To paraphrase, he wanted someone who would overturn Roe v. Wade, prioritize the religious freedom of a corporation over the rights of its employees, and upholds an expansive view of the Second Amendment. With this direction, the Heritage Foundation and the Federalist Society prepared a list of 21 judges who would meet the president's litmus test and their conservative requirements. For the first time ever, the President of the United States turned over, proudly, his constitutional duty to nominate a Supreme Court justice to conservative right-wing groups. Over the past month and a half, these groups and their secret funders have spent over $10 million to support this nomination. No doubt because their donors have confidence about how Judge Gorsuch will rule on so many of the tough cases that will come before the Supreme Court. It's why I've been so persistent, along with my colleagues on this side of the aisle, in asking him questions to get a sense of what his judicial philosophy would be. This is a critically important question to answer before we decide to give Judge Gorsuch a lifetime appointment to the highest court in the land, from which there is no appeal. These are the kinds of serious questions I would ask of any nominee, whether the nominee had been one of a Democratic or Republican president. But when I asked Judge Gorsuch serious questions to understand his judicial philosophy, he told us that his words, his views, his writings, and his clearly expressed personal views in the past had no relevance to what he would do as a justice. During the hearing, many of my Republican colleagues echoed the same view. They said that credentials are enough and that our real questions about Judge Gorsuch's record and philosophy were somehow irrelevant or even inappropriate or unfair. But this argument, just like the well-funded campaign by right-wing groups to confirm Neil Gorsuch, obscures the real stakes. It obscures the real impact of Judge Gorsuch's record of favoring corporations over individual rights. It obscures the very idea of what it means to be a justice on the Supreme Court. In my view, we should evaluate this nomination with the clear understanding that there is a great deal of difference between how a Justice Gorsuch would approach the kind of tough cases that comes before the Supreme Court and say what a Justice Merrick Garland would do. Does judicial philosophy matter? Of course it does. Otherwise, we wouldn't have so many 5-4 Supreme Court decisions that impact millions of lives. To illustrate, we know that Justice Scalia and Justice Ginsburg, both legendary jurists and actually close friends, they used to go to the opera together, would reach dramatically different results in cases that matter deeply in the lives of millions. Cases like Shelby County, like Citizens United, like Lilly Ledbetter, like Hobby Lobby, like Roe v. Wade. For the people who need justice most urgently, a justice's view of the law can make a world of difference. The working families, women, differently abled, people of color, the LGBTQ community, immigrants, students, seniors, and our Native peoples, these are the people who will be impacted by the decision a Justice Gorsuch would make. Yet an understanding of these people, their lives, and how the court's decisions would impact them is what I found to be missing from Judge Gorsuch's view of the law, even though he told me that the purpose of Article III courts, the federal courts, is to protect minority rights. For example, the narrow interpretation Judge Gorsuch took on the Individuals with Disabilities Education Act, IDEA, would have left Luke Perkins and thousands of special needs children like him without a chance to make real educational progress. The Supreme Court unanimously rejected and criticized Judge Gorsuch's narrow standard in a case just 2 weeks ago. His standard was too much, even for Justice Roberts. In the case of Alphonse Madden, Judge Gorsuch's narrow approach to the law was content to leave Mr. Madden with a terrible choice between freezing to death or being fired. And Judge Gorsuch's decision in Hobby Lobby found an expansive new right to religious liberty for a corporation that employs thousands of people. I always thought it was odd that people would describe Hobby Lobby as a family-owned business when they actually employed over 20,000 people all across the country. His decision made no assessment of the terrible impact this decision had for the thousands of working women at the Hobby Lobby company who would now be denied access to contraceptive coverage. A careful reading of Judge Gorsuch's decisions reveal a pattern of being on the side of corporations and against the side of individuals, continuing the clear propensity of the Roberts Court to support corporate interests over individual rights. We can see this when he narrows the law in ways at odds with the law's purpose and well past the point of common sense, such as in the trucker case, or when he throws up his hands and tells Congress to do better next time if we disagree with his narrow reading of relevant law. There are plenty of credentialed judges and smart judges, but credentials are not enough, not for the Supreme Court, or any court for that matter that makes decisions that impact so many lives. We have also heard the argument that the Democratic opposition to Judge Gorsuch's nomination is somehow unfair in contrast to Republican treatment of President Obama's Supreme Court nominees. It is hard to believe that anybody can make these arguments with a straight face. Every Republican on this committee, except for Senator Graham, opposed the nominations of both Justices Sotomayor and Kagan. These arguments omit any mention of President Obama's third Supreme Court nominee, Merrick Garland, the moderate well-credentialed, well-respected Chief Judge of the D.C. Circuit. Yet though his nomination was pending for nearly a year, he was never given a hearing, let alone a vote, and many Republican senators did not even extend the courtesy of meeting with Judge Garland. Senate Republicans kept the seat open for a year after Justice Scalia's death in an unprecedented, arrogant act. Apparently, President Obama's nominee didn't even deserve the kind of hearing that we have accorded to Judge Gorsuch. In fact, several Republican senators suggested during the campaign that they would be comfortable keeping this seat on the Supreme Court open and for more 4-4 decisions for another 4 years if Hillary Clinton had gotten elected. Now that Donald Trump is president, has made his pick, Senate Republicans have rediscovered their sense of urgency in filling this seat. They have argued that it is an improper abuse or even a personal affront to Judge Gorsuch if we don't rally to confirm him and do it lickety-split. I have serious concerns about the plans by the Senate's Republican leadership to jam this nomination through more quickly than for any recent Supreme Court nominee. Majority Leader McConnell's intention is to confirm Judge Gorsuch by the end of this week, and he has said he would do this one way or another. Judge Gorsuch will be confirmed per Majority Leader McConnell, the same person who said we will have no hearings on Merrick Garland. So this vote would come after only 4 days of floor debate, less time than for any Supreme Court nominee, dating back to at least 1975, far short of the 13 days on average the Senate takes to debate a Supreme Court nomination. Having left the seat open for almost a year and with the stakes of this lifetime appointment so high for the American people, people might rightly ask, why the rush? Why force the issue and create a crisis? Why not, in the best tradition of the Senate, allow for serious debate around such a critical nomination? From reports, it seems that part of the answer is that Judge Gorsuch's supporters, including the right-wing groups who have launched a $10 million campaign on his behalf, want him on the court by the middle of this month in time to hear a particular case called Trinity Lutheran Church v. Pauley. They want him to rule on this case which would tear down important, long-standing barriers protecting our constitutional separation of church and state. This undermines all the right-wing protestations that Judge Gorsuch's approach to the law and judicial philosophy don't matter. Judge Gorsuch's supporters want him on the court to hear a particular case with major ramifications, and they clearly have a very good idea of how this nominee, their nominee who was selected by them, would rule. Just as they are confident he meets their litmus tests and the litmus tests of the president who nominated him. This is no reason to rush our consideration or deny the Senate and the American people the time for a serious debate on this nomination. Doing so would undermine our constitutional role of advice and consent. A Supreme Court vacancy isn't just another position we must fill in our federal judiciary. A Supreme Court vacancy is a solemn obligation we owe to future generations. The central question for me, in looking at Judge Gorsuch and his record, in listening carefully through 4 days of hearings, is whether he would be a justice for all of us or a justice for some. I do not believe Judge Gorsuch will be a justice for all of us. I will not support his nomination.
Thank you. Senator Tillis.
Thank you, Mr. Chair, and I want to join the chorus of people thanking you for your leadership.
We got just 2 speakers left, and then we'll immediately go to the vote, so I hope everybody can be back here. Yep. Go ahead, Senator Tillis.
I'm going to be brief and save most of my comments for the floor speech. I do want to thank Senators Crapo and Flake for wearing Tar Heel blue ties today. That's a good luck sign. Mr. Chair, I'm not going to repeat what's been said by everybody else here, except to say that I really appreciate, I was going to say Lindsey Graham, Senator Graham's leadership and consistency on this issue. The fact of the matter is, in spite of the fact that there were statements out there by Whitehouse staff. Kagan is a progressive in the mold of Obama himself. Elena Kagan is clearly a legal progressive and comes from the progressive side of the spectrum. And then President Obama himself said that he wanted judges that had the quality of empathy. I thought we saw the exact opposite of that in Neil Gorsuch. He recognizes there's no place for empathy on the bench. And I bet that he had empathy for Luke P. What he told in response to one of the questions asked by my friends on the other side of the aisle, he said in response, "It's not my job to do your job." Some of the cases that we're having concerns with here are because there were members who passed laws that were either not clear or incomplete with respect to how they would have liked the judge to rule. If you take a look at Hobby Lobby, then ask yourself why one of the primary sponsors of RFRA when he was in the House, Senator Schumer, obviously had a hand in Obamacare here. You all had a supermajority, exempt the ACA from RFRA. You could go back and look at the IDEA in the case of Luke P. Everybody that's high-fiving on the judge or the decision last week is missing the point that it's still the inaccurate policies that were passed out of Congress that are going to still cause children or cause parents and children with autism the ability to have an educational choice that makes sense. We've still got to do our job here. I'm glad that it was brought up by so many members because I hope I can count on your support for a bill that will take care of that. You go on extreme and unqualified. The only way you can use those words for Neil Gorsuch is to say he's extremely qualified. He deserves confirmation on the bench. The number of times he's voted in the majority, the number of times it's been unanimous, we don't have to go through that. But I'll tell you what, if I'm a judge on his circuit, I dang sure wouldn't want to come before this committee because it sounds like y'all have the same argument for voting them down. They share the same record when it's 99 and 97%. So you're shutting down a whole circuit in terms of a future pipeline of judges. It'll be curious if we see one in the future, whether or not there will be some intellectual consistency and honesty when we do that. But, Mr. Chair, consistent with my practice of remaining brief, I'm going to conclude my remarks also to say I look forward to confirming Judge Gorsuch. He deserves to be on the bench. I regret that it may have to be done under the circumstances that we're doing because it will necessarily mean that the other judges that we have for potential other vacancies in this administration will not come from the pool that Judge Gorsuch did. And that's as a result of forcing a partisan filibuster, which is almost certainly not going to succeed. And finally, I do also look forward to supporting the nomination and confirmation of Mr. Rosenstein and Ms. Brand. Thank you, Mr. Chair.
Senator Kennedy.
Mr. Chairman, you've done a terrific job with these hearings. I think everybody's had their say, and I appreciate that. I want to make 3, maybe 4 quick points. Number one, there are, of course, 2 issues before the Senate. The first is, should we affirm or should we not affirm Neil Gorsuch to be an Associate Justice of the United States Supreme Court? But there's an equally important second issue, and that is, should we get to vote at all? Now, the first issue is pretty straightforward. You either vote yes or no. And, of course, this won't be a unanimous decision. Sometimes reasonable people disagree. Sometimes unreasonable people disagree. But we all have our personal beliefs, and as members of Congress, we're allowed to vote them, and we're all from different states, and this is a diverse union, and I think everybody understands that and appreciates that. But the second question, should we get to vote at all, is just as important, if not more important, than the first question. Now, everyone here has the right to filibuster. And our friends who happen to be Democrats have the right to filibuster and prevent us from taking a vote. It will be a first. There has never been a Supreme Court nominee by either a Democratic president or a Republican president who has been filibustered to death for partisan reasons in the history of the United States Senate or in the history of the United States. And there's a reason for that. It's because nominations to the United States Supreme Court are different from bills. And they should remain different. And my friend Senator Durbin, I was listening carefully, he talked about this process becoming like the movie Casablanca. You filibuster this nomination to death, and it'll turn to the movie The Hateful Eight. Or if you allow the partisanship on the legislative side to bleed over to the Supreme Court side, it'll at least become a Quentin Tarantino version of Groundhog Day. And I don't think that's what the American people want. And I don't think that's what they deserve. Point 2. Judge Gorsuch has been accused of having an agenda. Look, I'm not buying it. I didn't read all 2,700 opinions, but I read about 20, and I looked for an agenda because I don't want a politician on the United States Supreme Court. I don't want somebody blinded by ideology. I want a judge. I read at least 20 of his opinions, and I'll tell you what I saw. I saw the same thing over and over and over again. I'm going to read you 2 sentences from A.M. v. Holmes, where, by the way, he voted against a police officer. Not for, he voted against a police officer who arrested a 13-year-old 7th grader for fake burping in class. Judge Gorsuch said, I don't think you need to arrest him. Maybe discipline him, but don't arrest him. The majority said, oh, it's okay, he can be arrested and the police officer has qualified immunity. Judge Gorsuch said that's a bridge too far. And in dissenting, this is what he said. And you see this language time and time and time again. Quote, often the law can be an ass, an idiot. He's quoting Charles Dickens. And there is little we judges can do about it. For it is or should be emphatically our job to apply, not rewrite, the law enacted by the people's representatives. Indeed, a judge who likes every result he reaches is very likely a bad judge, reaching for results he prefers rather than those the law compels. Now that, my colleagues, is not an agenda. That's a judge. Point 3. Some have criticized Judge Gorsuch for voting for the big guy or the big gal, whatever that is. Here's a commitment, Mr. Chairman, I'll make to you and to God and country. As long as I'm on the Judiciary Committee, if this president or any president ever nominates someone to serve in the federal judiciary who says that he or she will be influenced by the wealth or the power or the status of the parties, I will vote against them. And you can take that home to mama every single time. Because the wealth and the status and the power of the parties should have absolutely nothing to do with who wins a case. Point 3. Judge Gorsuch has been criticized for not telling us what his position is on abortion. And he's been criticized for not telling us what his position is on gun control. And he's been criticized for not telling us what his position is on the 8th Amendment or the 10th Amendment or the 9th Amendment. And he's guilty. He can't He would violate his oath of office. He would violate the oath of office he took to be on the 10th Circuit Court of Appeals, and he'd violate his oath of office that he's going to take when he becomes an Associate Justice of the United States Supreme Court. Look, here it is. Canon 3A6 of the Code of Conduct for United States Judges. It says, quote, a judge shall not make public comment on the merits of a matter pending or impending in any court. Here it is, Rule 210B of the American Bar Association Model Code of Judicial Conduct. Quote, a judge shall not, in connection with cases, controversies, or issues that are likely to come before the court, make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of the judicial office. Criticize him for what you want, but don't criticize him for what he can't do, for violating his oath. Mr. Chairman, we all entitled our opinions. That's what's great about America. I've been around a lot of smart people, some of whom I met in the last 90 days. But this man is a thoroughbred. He's a legal rock star, as far as I'm concerned. And I'm going to vote for him enthusiastically. Thank you, Mr. Chairman.
Thanks, everybody, for being courteous to everybody else and hearing everybody else out. We're now ready to vote on the nomination of Judge Neil Gorsuch to be Associate Justice, Supreme Court. I would ask the clerk to call the roll.
Mr. Hatch.
Aye.
Mr. Graham.
Aye.
Mr. Cornyn. Aye. Mr. Leahy.
Aye.
Mr. Cruz.
Aye.
Mr. Sasse.
Aye.
Mr. Flake.
Aye.
Mr. Crapo.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy.
Aye.
Mrs. Feinstein.
No.
Mr. Leahy.
No.
Mr. Durbin. Mr. Whitehouse.
No.
Ms. Klobuchar.
No.
Mr. Franken.
No.
Mr. Coons.
No.
Mr. Blumenthal.
No.
Ms. Hirono. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 11 yeas, 9 nays.
According to the vote, a majority having supported the nomination will be reported to the floor. As I mentioned earlier, I'll put my statement in support of both Mr. Rosenstein and Ms. Brandt's in the record. I'm not going to take time to speak on them now, but they're both highly qualified nominees, and I said earlier it's imperative that the Justice Department have senior leadership in place as soon as possible, and I would like to call on Senator Feinstein.
Thank you, Mr. Chairman. I intend to vote aye on Mr. Rosenstein and no on Mrs. Brand, and I'd like to put a statement in the record, if I may.
Your statement will be put in the record. Anybody
Thank
else
you.
want to speak? Senator Klobuchar.
Yes, I'm going to also put a statement on the record on Ms. Brand. While I'm voting no today, I have some questions that haven't been answered, and so right now I'm voting that way, but I want to see if I can get some answers. I didn't get answers at the hearing because we had both of them together, and I have some follow-up questions. Thank you.
I don't see anybody else requesting time, so I would ask the clerk to call the roll.
On Rosenstein?
Yeah, Rosenstein.
Mr. Hatch. Mr. Graham.
Aye.
Mr. Cornyn. Mr. Lee. Mr. Cruz.
Aye.
Mr. Sasse.
Aye.
Mr. Flake.
Aye.
Mr. Crapo.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy.
Aye.
Mrs. Feinstein.
Aye.
Mr. Leahy.
Aye.
Mr. Durbin. Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Franken.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
No.
Ms. Hirono. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 19 yeas, 1 nay.
Majority of the committee having supported it, the nomination will be reported to the floor. Anybody want to speak on Ms. Brand? Okay. I think we're ready to vote then. Clerk will call the roll.
Mr. Hack.
Aye.
Mr. Graham.
Aye.
Mr. Cornyn. Mr. Lee. Mr. Cruz.
Aye.
Mr. Sasse.
Aye.
Mr. Flake.
Aye.
Mr. Crapo.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy.
Aye.
Mrs. Feinstein.
No.
Mr. Leahy.
No.
Mr. Durbin. Mr. Whitehouse.
No.
Ms. Klobuchar. No. Mr. Franken.
No.
Mr. Coons.
No.
Mr. Blumenthal.
No.
Ms. Hirono. No. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 11 yeas, 9 nays.
Okay, a majority of the committee in favor of Ms. Brand. The nomination will be reported to the floor. Committee meeting is adjourned. Thanks, everybody, for their participation.
Thank you.